Good morning. In accordance with Sections 45 and 53 of the Planning Act 1990 as amended, this meeting of the Committee of Adjustment of the City of Toronto is called to order. My name is Zahir Bryant, and I'll be chairing today's session. Panel members today are Gary McKay, Ann Crawford, Peter Reid, Philip Ghosh. And Secretary-Treasurer today is Nicole Ivanov. We acknowledge the land we are meeting on is the traditional territory of many nations, including the Mississaugas of the Credit, the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat peoples, and is now home to many diverse First Nations, Inuit, and Métis peoples. We also acknowledge that Toronto is covered by Treaty 13 with the Mississaugas of the Credit. Committee of Adjustment public hearings are now conducted in a hybrid, in-person, and virtual format. Some applicants and participants will make their submissions in person, and others will participate virtually by electronic means through WebEx. The meetings are also streamed on the Toronto City Planning YouTube channel, and anyone wishing to view the hearing may watch on YouTube. Those who want to participate virtually and have registered in advance will be connecting with their computers or telephone and have the option of participating via video or audio only. When your item is called, you will be unmuted by the moderator. For both in-person and virtual participants, Committee of Adjustment staff will share presentations submitted in accordance with the written submission deadline. People attending in person today who want to receive a copy of the decision of the committee on an application must fill out a decision request card, and those participating virtually need to submit a written request for a decision by email. If you do not agree with the decision of the committee, you may be able to appeal the decision to the Toronto Local Appeal Body, or in some limited circumstances to the Ontario Land Tribunal. However, the provincial government amended the Planning Act and generally removed rights of third parties to appeal Committee of Adjustment decisions. Only the applicant, the Minister of Municipal Affairs and Housing, specified persons, and public bodies are permitted to appeal decisions of the Committee of Adjustment. Appeal instructions are set out at the bottom of the decision of the committee. Today, I will call each item in the order listed on the agenda. Pardon me. Where an application is uncontested, the agent or applicant may proceed with a presentation if desired. When the committee does not require presentation, applicants are to advise the chair should they wish to speak to the committee. The committee may ask questions and/or take the matter into committee for a decision. Each speaker, including the applicant, will be given a maximum of 5 minutes to address the committee. I will comment when you are reaching the 5 minutes. Any presentation or other material, members cannot accept materials at the hearing. When addressing the committee, please clearly state your name and address. Please remember to confine your remarks to the matters outlined in the application. The applicant or agent will proceed first and will make a presentation to the committee on the application. Then individuals, either in support or opposed to the application, will be invited to speak. Generally, we first call on speakers in the hearing room and then those participating through WebEx. Committee members may ask questions of each speaker after they have finished their presentation. When all speakers are finished, the applicant or agent has an opportunity to rebut only those issues that were raised by the speakers. This will mark the end of the discussion. The application will then be taken into committee for a decision. Madam Deputy Secretary-Treasurer, are there any minutes of the last meeting that require adoption?
Good morning, Mr. Chair and panel members. No, there are no minutes ready for adoption in today's hearing.
Thank you. Are there any declarations of interest of panel or staff for items in these time slots?
See none from staff.
No. Thank you. Madam Deputy Secretary-Treasurer, have you received any requests for deferral?
Through you, Mr. Chair, before we get to deferrals, I'll also state for the record there are no files to be closed or withdrawn this morning. With respect to morning deferral requests, there is one deferral for this morning's agenda due to improper signage. That is item number 11, municipal address of 111 Emerson Avenue, file number A0164/26TEY. We do have the agent and no registered speakers.
Thank you very much. We can address that item now, I take it. Okay. Item number 11 is 111 Emerson Avenue, and the purpose of the application, sorry, did you say the agent was present? Oh, wonderful, thank you. Oh, online, thank you. I beg your pardon again, I'll start from the beginning. Item number 11 is 111 Emerson Avenue, and the purpose of the application is to alter the existing two-story semi-detached dwelling by constructing a new front ground floor deck with stairs and privacy screening located beyond the existing front enclosed porch. The committee had before it the following communication: copy of plan of survey, site plan, floor plans, and elevations, 4 photographs of trees on the subject property, received February 24th, 2026. We have a deferral request from the agent, a decision number affecting the subject property, and an OMB decision and order number affecting the subject property, email correspondence between the agent and Transportation Services. And we also have correspondence in support from 477 Margueretta Street.
Through you, Mr. Chair, we have the agent online and no registered speakers.
Thank you. Let me just get to. Okay. Good morning. Is that Lawrence Gaines? Are you there? Lawrence
I'm the
Gaines?
agent. Yeah, I'm Antonio. I'm the agent, but I believe Lauren, she might be in person. I'm not too sure. I can see the audience.
Okay, thank you so much. But you're here to request a deferral today.
Correct. Yeah, my name is
Thank you.
Antonio Moraes at 71 Mayor Crescent address. I'm the agent representing Lauren, the property owner. And yeah, correct. So unfortunately, we deeply apologize for missing the deadline for the signage. The system, I believe, sends the messages automatically to the property owner. And myself as the agent, I ended up missing that. And the property owner was traveling abroad during the time she got the notice. So that's why we missed the deadline. We really apologize for that. That's the reason for the deferral.
Okay, thank you. We don't have anybody in opposition, so we don't need to address anybody else. So we'll take it into committee and look for a response for you. Oh, Phil?
Sure. A need to have proper signage is fundamental for these hearings. And so it seems appropriate to defer as per the deferral request. I move to defer it.
Thank you very much. Do we have a seconder? Mr. Reed, thank you. All those in favor of a deferral? Thank you. You have your deferral, sir. Thank you.
Thanks. Thank you.
Through you, Mr. Chair, we don't have the agent online for items 1 and 2. I'm going to continue to try to reach them.
All right, thank you. Then we can perhaps move on to item number 3. Okay. Item number 3 is 102 Glen Road, And the purpose of the application is to legalize and maintain the 3-story detached dwelling, reviewed as a new dwelling as more than 50% of the first floor walls are demolished, with a side north second level deck currently under construction. Foundation, superstructure, deck, and main floor garage wells are constructed beyond the limits of the authorized building permit number 23209-864 BLD00SR. Minor variance decision A 0390/23 TEY approved alterations to the existing 1.5-story detached dwelling by constructing a complete second-story addition with a side north second-level deck and reconstructing the basement-level water feature with a tiered water fountain. The committee had before it the following communication: copy of plan of survey, site plan, floor plans, and elevations, 10 photographs of the subject property received January 16, 2026, a cover letter from the agent and decision numbers affecting the subject property. There are 3 decision numbers. Correspondence from the agent, tree inventory and preservation plan report, a building permit affecting the subject property, orders to comply, 2 orders to comply affecting the subject property, a stop work order affecting the subject property. We also have commenting agency reports, staff reports from Urban Forestry, Toronto and Regional Conservation Authority, and we also have correspondence in opposition from 1 to 2 folks with no addresses provided. We also have correspondence from Midtown Ravines Group, South Rosedale Residents Association, North Rosedale Residents Association, 47 Chestnut Park, 2A Lamport Avenue, the ABC Residents Association, and 100 Glen Road. Okay.
Through you, Mr. Chair, we have the agent online and speakers here in person and 1 speaker online.
Thank you. Mr. Fodrick, are you there? Michael Fodrick, are you there?
Hello, can you hear me?
Hi, good morning.
Good morning. Just working out the mute button.
That's okay.
Thank you for the chance to present today. This is
just your name, full name and address,
sure.
please, for the record.
Thank you. Michael Fodrick, spelled Foderick. I'm a lawyer, planning and development lawyer from McCarthy Tatro, and I'm here on behalf of the applicant, Mr. Tony Lima. The application relates to 102 Glen Road, and in the many minor variances I've done, I've never seen so many variances that relate to one minor issue. And with your patience, I'll describe what that is. There was variances before this committee in October 2024, which were approved, and construction pursuant to those minor variances was underway. And those variances and that review that took place was premised on a renovated dwelling, and so the preservation, in other words, of existing walls, certain existing walls. And here, this is a good depiction of the subject site and subject property. During the construction, one of the walls failed and needed to be replaced. One of the walls that wasn't originally contemplated to be replaced. And if you are near a ravine, and if you are on an awkward shaped lot, and if your previous zoning review relied on the lawfully existing provision quite heavily of the zoning bylaw, being an existing wall can continue to be lawfully existing, even though it's a setback from the property line, respective setback is less than what would normally be permitted. That is a big problem. As it turns out, and that's exactly what's happened here. And so I cannot stress this following point enough. There is no change to the plans that were previously approved by this committee. These new variances are entirely as a result, as I'm about to describe, of the loss of that lawfully existing permission for that wall that was had to come down because it was structurally unsafe, ultimately, as it turned out, and it's being replaced with a new wall exactly in the same location, as well as 2 new variances that were flagged by the examiner that weren't caught, if you will, on the first round of variances, but they are straightforward, as I'm about to describe. I will just also emphasize before I speak to the variances themselves that you are in receipt of a letter from TRCA, who has been thoroughly inspected the site, thoroughly investigated everything, and has no concern with what's there. And in fact, we are permitted by the TRCA, and all the work has been consistent with their approvals and under their supervision. So let's look at the variances themselves. The very first one is related to a set of stairs, and this is that one I referred to, which wasn't caught in the previous review. This bylaw provision says that you have to be, when you have stairs to a front door, they must be really close to the established grade. Well, in this case, the established grade, because it's a ravine lot, because it's sloping, is measured from the front lot line. And so in this case, although it appears that we have a really high set of stairs, it's actually not a really high set of stairs. It's 0.3 meters from the nearby grade to where the stairs relate. So it is actually very much in keeping with the intent and purpose of the bylaw. But we have this established grade calculation, which again this provision isn't really designed with such sloped lots in mind. It makes it appear as though we have a really high set of stairs. But again, the stairs have not changed location from the previous plans. This is just something the examiner didn't catch the first time it went through. And I don't think any of us caught it because it's so counterintuitive that this would even need to be a variance. But again, I think it clearly meets the intent and purpose of the bylaw, and that the stairs are, in fact, as my covered letter and the plans demonstrate, within 0.3 meters of the door. So there's a small step, if you will, not as the largest step as this variance implies, because of just how established grade is measured. Second of all, and the third and second and third variances both relate to that wall I mentioned, and this appears to be very significant lot depth and building length variances, which again are just they previously weren't required because there was a lawfully existing condition in place, and that wall had to come down as the construction was underway. So now a new wall is being erected in the exact same place, exactly the same as was contemplated in the previous plans, but it can no longer technically avail itself of those lawfully existing permissions, which again is frustrating, but it just shows you what can happen if, when you lose that one wall. Lawfully existing. Again, no change to what the C of A previously considered and approved. Now, what I might add, the previous building on the site, which was the subject of the previous C of A application. Number 4, there is no increase to the actual size of the building, although there appears to be, on the face of it, a significant increase to the FSI. And I can sympathize with anyone who might be confused with this at first glance. The way the bylaw works is that when you're calculating FSI, is a function not just of the GFA of the building, which has not changed, but of the lot area. And you discount from the lot area the area below what's called the stable top of bank when you're dealing with a ravine. And in working with the TRCA, they had a new place that they wished to draw that line for the stable top of bank. And so the result of redrawing that line at their request doesn't change anything about where the building was. It makes it appear that the variance is much larger than it was, but it's the exact same GFA, exact same building as it was before. And I just can't help but notice that if one were not to discount the land below the stable top of bank, as would not be the case for any other lot in the neighborhood, essentially, we'd be well below the as of right FSI. So this is not something that is controversial. Finally, I'll just say, subject to your questions on the final variances, we already obtained a variance approval for this issue, which is set back to the ravine. Again, it's consistent with the existing building. So why are there these variances here when they've already been obtained? Well, again, the examiner, there's a general provision which applies to all ravines, and then there's site-specific exception, 1438, as you'll see there in number 7. And we already obtained that variance, and we don't think actually you need these variances again.
Mr. Podrick, could you wrap up? Your time's up.
I will. And I'll one more sentence, thank you, just to say that typically when you're reading zoning bylaw, and always in fact, the site-specific displaces the general. And that's what we say has happened here. But out of an abundance of caution, if you will, the examiner's thrown in both the general and the site-specific provision. We've already gotten relief from the site-specific, and so here it is repeated again. But they've also included the general, which I don't think is right, but that's why we're asking for it.
Thank you.
Thank you for hearing me out.
Thank you. You'll be able to elaborate as we go through the. Let me just check and see if my colleagues have any questions for you at this point. Seeing none, I do have one question for you. I was looking at the previous decisions, and I remember being on the committee when you had, I think it was perhaps the last decision and it was approved. But what I don't recognize is, I think in this particular application, you've got variance number 3, variance 2 and 3, length and depth, and particularly depth of 48.6 meters, which doesn't seem to be on any of the previous applications, but it is on this one.
Right. And as I said, it wouldn't be. And the location of the building has not changed since that previous application. The size of the building has not changed. The only reason those variances appear now and they didn't before, even though the wall is in the exact same location, is because before it was an existing wall that was being maintained, and we were tearing down the rest of the building and keeping that wall. And during the construction process, the wall was structurally unstable, and a decision was made to remove it for that reason. Probably they should have gone to greater measures to keep it because it's caused a lot of grief as a result. But the point is that the building wall has not changed, and there's a provision in the zoning bylaw for lawfully existing setbacks, including of walls like that one, where you have a lawfully existing setback, which this was, that no variance was required for that. And so, but when you tear down the wall, you lose that lawfully existing.
So, sorry to interrupt you, but are you saying that the depth was already there? And so it's only here before us because of the wall collapsing and presumably being rebuilt. Would that be correct?
Exactly. And I'll also add, sir, is that when you look at the plans themselves, it is an odd shaped lot, if you will. And so, it's not a normal rectangle where the measurement of lot and depth and all there are other considerations one might look at to say, okay, that's appropriate in this case. But suffice to say, this is strictly related to the wall. The wall, I cannot stress enough, the depth, the location of the wall in question has not changed from the previous application, as you can see.
Okay. But sorry to interrupt you again. I don't want to have all the discussion monopolized at this point. Just one other quick question for you. We have had, I think, 2 orders to comply.
Right.
Is there some reason why, the folks in doing the construction ended up engaged in construction that wasn't allowed and having to have these orders to comply?
Once that wall came down, it made the whole thing illegal, as you can see, right? It was, and they really had to stop work in the middle of the construction. And again, they say the wall was unstable and it had to come down, but that's the only unauthorized construction, is that once that wall, which was unstable, came down, it made we no longer had all the variances we needed, as those setback variances in particular.
Okay.
So that's the frustrating part about this, but here we are to try to fix.
Thank you so much. We'll move on to folks in opposition who, we may have somebody here, I believe.
Through you, Mr. Chair, we have a number of speakers in person.
Wonderful. Thank you so very much. Good morning.
Good morning, Mr. Chair and
Hi,
panel.
good morning.
My name is Sarah Turney. I am here as agent on behalf of Cecily and Robert Bradshaw, who are the neighbors, the immediate neighbors to the subject site at 100 Glen.
And your address?
My office is Faskin Martineau, which is 333 Bay Street, Suite 2400.
Thank you very kindly. You have 5 minutes to make a deputation.
Thank you. So Cecily and Robert are here in the room. They've provided a detailed objection letter that outlines the reasons they are seeking refusal of this application. I'm really here to just highlight a few important points. First of all, the submission that this is simply putting back what was already approved does not accurately tell this story. And I want to emphasize something very important. The applicant relies on a prior approval of this committee from October 2024. If you look at that approval, what it says, and this is what was represented to this committee and what was approved, was to alter the existing 1.5-story detached dwelling by constructing a complete second-story addition. So this is a photo from our submission. This is nothing new. But this is the...
Sorry, we won't be able to accept that it's not been submitted.
Okay, it is in our objection letter. It's just a blow up of the photo. But if you prefer I not hold it up, that's fine. So
I think if it's already been submitted, then we can ask for it to be pulled up on the screen.
Okay, so it's in the objection letter. So if we could pull it up on the screen, that would be great. I just see my time is ticking away, so I'm going to keep going. Thank you, Mr. Chair. Should I wait?
Yeah, the clock can be paused.
Reset. Okay,
Thank you.
amazing. So it's the objection letter on behalf of Cecily and Robert. Which is 100 Glen. Wonderful. And if we scroll down just a little bit, you're going to see the photo of what the existing dwelling was. There we go, side by side. Okay. So the important point that I wish to make is that that dwelling has not been altered or renovated to create a second story. It has been entirely demolished, and what has been put in its place, and this is right on the face of the application, is a much larger structure with a third story. And so if what the applicant is saying is, oh, this was always what the plan was, that should have been made clear to this committee in October of 2024, because that is a larger structure with a third story. You can also see, if you scroll down, Mr. Chair, just a bit, we've included side profiles that demonstrate that this property has in fact been extended back further into the ravine setback. In any event, it is our respectful submission that now that the applicant is back before this committee, it is incumbent on them to demonstrate that the 4 tests have been met. And they have not. Let me explain. Number one, the applicants have submitted a lawyer's letter. Page 7 of that lawyer's letter, there are 3 short paragraphs that say why the applicant states that this is desirable and appropriate for the neighborhood. There's no analysis of how the removal of trees is appropriate, how the setback into the ravine of more than 50% is appropriate, no analysis of the character of the neighborhood, no analysis of how that massing would fit. Number 2, and this is critically important, they have given you 6 so-called comparables. 5 of those 6 are not near a ravine. 5 of those 6 do not have a TRCA regulation. 5 of the 6 do not have a natural heritage overlay. Those aren't comparable properties, Mr. Chair and panel. They don't have any of the same regulatory structure of 102. The 6th property, and we've included a picture of it in our objection letter, is a heritage red brick home. Nothing like what is being constructed here. So it is our submission that you simply do not have the evidence before you to establish that this application meets the intent of the zoning bylaw or the official plan or is desirable. The ravine, Mr. Chair and panel, is important to people. That's why you've received objection letter after objection letter referring to how this more than 50% setback, encroachment into the setback is inappropriate. Our clients bought 100 Glen to be near the ravine. They're a retired couple who intend to spend the rest of their life in 100 Glen, and they rely on the zoning bylaw, which contains a 10-meter setback to protect that ravine. And there's nothing before you that would provide the evidence necessary for you to make the determination that a more than 50% encroachment is in keeping or is appropriate. The final thing I will say is it's probably clear that we're seeking refusal, but in the event that any of the variances are approved, we would ask that the committee apply the conditions that we've set out at the end of the letter, including that this be tied to the existing plan so there are no more sort of switcheroos, and to ensure that it is a single family dwelling that is constructed as there are discrepancies, and we've set them out in the letter with respect to what is being built. Those are my submissions. Thank you very much for your time. I'll be pleased to answer questions.
Thank you very kindly. Thank you also for the submission. Mr. Ghosh?
Are you disagreeing with the position of the applicant that what they're building is what was in the plans that were before the committee previously?
Yes.
How?
So I'll note a few things. Number one, in the application package, when I've reviewed the material that is available to the committee online, I don't see the prior plans that were before you. What I see is the description of the property that was approved, and it is not the same as the description now.
Okay, so it's based on the description, not based on a review of the previous materials.
I'm unable to do so because I don't have the complete package, but I think what's also important is that the prior depth that the applicant refers to, and we know this because our clients used to own that home, the prior depth was a cantilevered second story. Okay, so it did not include an encroachment that actually dug down into the basement and removed the soil in the ravine setback area. This structure does. And so that's also a key difference that I don't see identified anywhere.
Mm-hmm. And would you agree that when you characterize it as a 3-story structure, that's basically saying that the basement walkout is the first story? Because from the image, it looks like a 2-story from the image that you showed us.
That's my understanding. That's that structural change that sort of took out the patio that existed there and dug down. Yes.
Okay, thanks.
Thank you, Ms. Ghosh. Any other questions? No, none? Thank you very kindly.
Thank you.
And we'll move on to the next applicant. Thank you.
Through you, Madam Chair, or sorry, Mr. Chair.
Okay.
There is a number of observers for item 3. Is there any other speakers in person? All right, then I'll move on to the speaker online.
Okay, thank you.
Olm, you've been unmuted.
Hi there. Can you hear me?
Yes, we can, Mr. Shoshay. If we could get your name and address, please.
Yes, will do. Good morning, Mr. Chair and committee members. My name is Colm O'Shea. I live at 8 Dale Avenue, and I am a member of the South Rosedale Residents Association. My comments this morning are shared to you on behalf of the South Rosedale Residents Association. The SRA, most will probably be aware, we represent the residents of South Rosedale, representing over 800 homes. The South Rosedale Residents Association is a not-for-profit volunteer organization. We're dedicated to preserving the character and quality of life in Toronto's South Rosedale neighborhood. We were incorporated in 1931. We are one of Canada's oldest and most active ratepayers group. In matters of construction, heritage, and development, the SRA prefers to dialogue with neighbors and builders ahead of construction to fully understand the scope and impact of each proposal. Many and most builders choose this route, which allows South Rosedale to ensure the development follows the city's guidelines. In cases where we are blindsided and not informed, the SRA is often called in after the fact, which happened in this property specifically. If the matter is determined to adversely impact one of our residents or threatens to impact one of our precious parks and ravines, it is the SRA's responsibility and duty to become involved. Regarding 102 GLEN, the SRA has identified several areas of concern with the proposed building. First, we are aware that the neighboring homes are objecting to it, and this has been coming to us for the last 2 years. Issues, and this one probably is most vital and most important to us, is there are encroachment issues with our ravines. It is our opinion that 102 GLEN Road project, unfortunately underway, and it always seems to be underway, stopped, big fences put up, don't take photographs. It was a very precarious kind of build in our neighborhood. We've never really encountered something like this. These variance requests appear to be going beyond the already liberal city guidelines. For residents associations across the city, failure of any project to meet the city's minimum standard is a red flag for us. The SRA supports and always advocates that our residents, when we are approached by them of a future build, we are told, please follow the city guidelines. This project did not hit our desk. The builder did not come to us. The builder did not dialogue with us, which we normally would dialogue with the residents nearby. So we feel that the city's guidelines are already adequate and flexible for our residents to achieve their desired goals. So we try to sort of negotiate or mediate between nearby neighbors and the neighbor building with what we think the city would like to have done to the property or it finds acceptable. Returning to this application, there are 7 variances. Variances 1, 2, 3, and 4, glibly stated by the lawyer representing the group, relate to height, depth, length, and floor space. As presented by the builder and today by the speaker, these 4 variances significantly exceed what is considered acceptable for the neighborhood. In fact, these so-called minor variances are in excess of 60 to 100% of the city's minor variance guidelines. When our sort of ad hoc group of concerned residents receive a package, this is not what we do on a daily basis, but we look at them and see if they're following the code that's given by the city. And we try to align ourselves with the city's guidelines. In this case, they're so broad at 60 to 100%, it's just difficult for us as a residents association to say, I think you're following the guidelines when they're not. So in this case, under 1, 2, 3, and 4, the SRA is unable to support the requested variances due to the exaggerated nature of these variances. Variances 5, 6, and 7 are related to the ravines and setbacks and far exceed the scope of the city's far exceed the liberal scope of the city's ravine strategy and building strategy. The SRA looks at all developments near parks and ravines with a more scrutinous lens, as the city's ravine strategy has strict guidelines and we totally support them. It is one of the SRA's key tenets to advocate for the protection of our precious parks and ravines, as our residents, like all residents in Toronto, value them. As such, the SRA is unable to support these requests.
Could you wrap up, please, Mr. O'Shea?
Yep.
Your time's up, so if you could just wrap up, please.
Yep. The Committee of Adjustment, as far as the SRA is concerned, plays a very valuable role in protecting our neighborhoods, of which we are grateful. The SRA requests that the committee refuse the application and encourage the applicant to reach out to the owners of the nearby properties, as well as the SRA, with the aim to developing a better solution for this unique lot bordering the ravine. Thanks so much.
You're very welcome. Thank you very kindly. Let me just see if my colleagues have any questions for you. Seeing none, we'll move on to the next speaker.
Through you, Mr. Chair, that's all the speakers. I can bring the agent back.
Okay, wonderful. Thank you. Mr. Podrick, are you there?
I am. I'm just going to briefly respond to some of the points I heard, thanking my friends for their submissions. First of all, in respect to Mrs. Turney, who said that, that it appears that her characterization of this is something different than what was here before is based on the description, and that, i.e., it was previously referred to as a renovated dwelling and now it's referred to as a new dwelling. I've already explained why it was previously referred to as a renovative dwelling and now it's referred to as a new dwelling. Again, the loss of those main walls, main wall in particular, is what I think the zoning examiner believes now characterizes a new dwelling as opposed to a renovated dwelling. That is a question of description. It's not a question of substance. So I don't agree with anyone who would say that that is a material change. That is a way that's described has been changed, but it's the exact same in substance. Second of all, she made some comments about there's no evidence before you about the ravine being protected and whatnot. TRCA has a letter in front of this committee which says it has no concerns, no objection, I think is the words they use. They have been all over this site. They have looked at it carefully. They're very diligent. There's no one, dare I say, who is more thoughtful and knowledgeable about protection of ravines than TRCA, and they have provided that letter, which again speaks for itself. And one bit of context, which they're certainly aware of, but not everyone who's here and listening may be, is that not only is this in line with the previous approval, but it's in line with the existence of the previous structure on the site. TRCA wouldn't normally approve buildings like this unless they were in the space of an existing building already, a long-standing building already there. Someone buying a ravine lot today I shouldn't expect to be able to build something. TRCA and other things don't approve that unless there is an existing building, and in this case, existing approval on there. So I think that is certainly the TRCA letter is strong evidence in addition to everything else we've heard. And there was a note about no more switcheroos. There have not been any switcheroos. I just can't. I don't know where their characterization is coming from. That's to put it mildly, unfair characterization. The suggestion was made, though, that there be a condition that this be tied to plans, and we wouldn't be concerned about that. The city planners haven't requested such a condition. We wouldn't object, though, if the committee just have whatever level of confidence that it wanted to add a fairly typical condition, which says that the approval in question should be tied to this plans filed with the committee. No problem there. The building is literally under construction, as you can see. And the images that Ms. Turney showed, again, the shock, if you will, that she tried to express with those images, those just depict what was already contemplated. This is not something that is new in terms of height or massing or anything else. And so turning quickly to the comments of the SRA, there was a reference made to a height variance. There is no height variance. There was reference made to the FSI variance, and again, I can sympathize with the SRA, maybe not having had the benefit of understanding this specific application and understanding how the FSI was calculated. I'll admit, it does appear on first glance that there's been an increase in density, but upon closer scrutiny, I think everyone here will discover, as I've said, that there has been no change to the actual GFA. The only change has been to the denominator, if you will, to the size of the lot. Namely that everything considered below stable top of bank is excluded from the lot area. Normally, you take the whole lot area and calculating as the denominator. Here, you take a portion of it. And the TRCA and subsequent reviews, they have determined that the lot is, more of it's below the stable top of bank than it did before. So it changes the FSI calculation. But if one were to calculate this in the typical way, as every other lot in the neighborhood is, we would be below the as of right. We'd be below 0.5. In fact, so anyway, it's a change to where the line is depicted, and that's well illustrated in our drawings, not a substantive change in terms of an increase in GFA or something like that. So I just want to thank my friends, and as I said, this is something that is literally under construction, and we've tried to follow the bylaws as best we can, and we're doing that by trying to seek this variance to fix the issue that's arisen with the wall. And there are some issues there, I think, that are highlighted here as to the condition of that wall when we actually revealed it, that talk about sort of the condition of that wall, and you can see the condition it was in. Anyway, thank you for hearing me out. Subject to your questions, those are my comments.
Thank you very much. Let me just see if my colleagues have any questions. Thank you. Mr. Ghosh has a question for you.
So the TRCA letter mentions a TRCA permit. So is that a permit that you applied for together with pursuant to the original proposal?
Yes, in short, but there are probably revisions were sought, or not revisions, I should clarify. We had them revisit the site more recently, if you will, to confirm that, because I think some of the neighbors called the TRCA suggesting that something untoward was happening. So we've had a number of conversations with them, and there may have been a permit revision to revise the stable top of bank location. And again, my colleague dealt with that, so I can't speak fluently about the exact timing of those permits. I can only tell you that you have in front of you something that says they don't object and that we have in our hands.
That's fine. My question really just is that it means that there is a TRCA permit,
correct,
with respect to this project.
Correct, and there has to be, and we will 100% honor that permit in every way.
The footprint of the home is how does it compare to the home that was there prior to doing this work?
That's a great question, sir, and it's not one that I feel completely competent to answer, to be honest, because my focus has been on the incremental, if you will, which is none. From the previous designs approved. I'm sure it was, I didn't represent this applicant before the committee and when they were previously here in October 2024. It was approved on the premise that this wasn't encroaching any further into the ravine than the previous building is my belief, but I wasn't there. I can only tell you that the TRCA doesn't normally, and the bylaws don't normally permit additional encroachment in the ravine in addition to anything that's already there. So I can't sort of speak to revisiting those things from the previous application very well, but it's my own experience. They don't typically allow you to go beyond what was already there. No changes occurred since that last October 24 set of plans. That I can be certain of. I'm hoping that's not as helpful as you'd like of an answer, but that's the best one I have for you.
Okay, thank you.
Thank you. Any other questions? Thank you. Ms. Crawford?
Thanks. I'm just wondering if you can speak to this issue that was raised by the agent for 100 Glen Road, that this application before us is to legalize and maintain a 3-story detached dwelling, and the 2023 one is a 2-story. And I understand there's perhaps a change to the plans in terms of the cantilevered
No,
second-story
no change.
addition.
There's been no change to the plans. There is no height variance of any kind, either in terms of stories or height in meters. Again, I'm not sure where that's coming from. I know that the SRA, perhaps someone's repeating some inaccurate information. As you can see, there is no height variance. There wasn't last time. This is within the as-of-right height. I think my friend is characterizing as a 3-story because of what we call a back split situation, where if depending on the angle you look at the building from, it may appear to be 3 stories, but that bottom story isn't counted as a story according to the way stories are counted in the bylaw, because of the way grade, it's below established grade. But nothing has changed from the previous approval. I think what she may be referring to is that, as was contemplated in the October 2024 plans, there was an existing building sort of footprint in that area, in a cantilevered nature, and those previous plans, as does these, contemplate that sort of, that area being filled in, but not expanding the footprint of the building into the ravine beyond what was there before. Again, there's no variances related to anything about height or stories or otherwise, and so I don't agree with the character. I think the bylaw defines it, and common sense defines it as a 2-story building, but that basement story, if you look at it from a certain, looks like a 3rd story, but the bylaw doesn't consider it that way. It's a back split sort of situation. I hope that's helpful.
And, yeah.
What my friend is referring to, and it is before us, is, the description of in the previous application does say 2 stories, and in the current one does say 3 stories. We also have that difference about the front step. So when I look at this, it seems to me that the different zoning examiners looked at the grade as being different, and that's what the difference is. But I'm wondering if you agree with that interpretation, or you have some other reason why it would have at one time been considered 2 stories and now is 3 stories, if it truly is the same.
No, it is truly the same, and thank you for that clarification, and in particular for pulling up this drawing, which I think illustrates that variance number 1 very well. Looking at the variance language itself, one might be misled to thinking that we're providing a big step up to the front, but this image clearly demonstrates that it's a 0.3 meter step. It's not the significant step. We couldn't, you can see the established grade is measured in the way the bylaw instructs from the front lot line, and there is a tapering off of the grade, so it's such that the calculation of established grade isn't intuitive when you actually look at where the door is located. Normally, lots are generally flat. This one is not in this case. So that's where, and again, you look at the 2 step, and we have quite a steep ravine, and so you take an average of the 2 without dissecting how you calculate established grade. That's why. So this is one that the previous examiner didn't catch. It is now caught, so to speak. I do agree it appears to be a variance. When one look and talk about the intent and purpose of the bylaw, the intent and purpose, you don't want really large, 2.55 meter steps up to a house. You don't want, that's almost a story tall. You don't want a story tall steps up to your front door. But no, that's not what actually is being built. It's a 0.3 meter step. It's just the way established grade is measured here implies something different than it is. So this is a classic, meeting the intent and purpose of the bylaw, if you will.
Yes, you've already addressed that, and so it's that same differential, you think, that makes it now a 3-story versus a,
And in my experience, sir, having done this a lot, I will, to be honest, you submit plans and you get, some examiners will catch something like this, some won't. It's a big bylaw with a lot of arcane provisions. I don't begrudge the first one for missing this, but I consider this one straightforward and very minor. And it's not anything untoward. If there's any doubt in this committee's mind about it's something different than what's depicted there, then please tie it to plans. Please put a condition, it's a fairly standard condition. We wouldn't object to that at all.
But just for
Ms. Crawford,
just for clarity and just to follow up, so I think the agent for 100 was particularly concerned that there was, in the new plan, as different from the earlier plan, there was going to be a deeper foundation and further encroachment in the ravine. Can you clarify that that's not?
Previous plan. Correct. No difference from the previous plan, no substantive change to the drawings themselves, only a change to the characterization of the building, the exact same plans. I heard her say that she hadn't even looked at the previous plans, is what I heard her say. So I don't think it's right to characterize her saying she compared the two and saw a difference. She said she hadn't seen the previous plans, and I'm advised that there is no difference. And again, if there's any doubt about something untoward happening, let's tie it to the plan so there's no misunderstanding about that whatsoever.
Any other questions? Any conversations? None? Okay, thank you. Ms. Fodrick will take it into committee and look for a decision.
Thank you.
All right. Maybe I'll just a couple of comments, if I may, Mr. Goshen. So, you know, I've found this one to be a little problematic from what is being asked for. If this was a completely new application, given the requests that are being that are put forward to us, I would find it very difficult to approve them. We're just looking at particularly variances number 2 and 3, also number 4. So if this was a new application that had come before us with these requests, I doubt if it would pass muster. And so this is where I have difficulty. And I also recognize, of course, that this is a home that was previously approved in 2024. And I happened to be on that panel as well at the time. But what was asked then is not being asked for now. So there's a big difference between what is being asked for previously, what was approved, and what is now being asked for. So I have great difficulty in reconciling that this is not dissimilar to what we had previously. So I'd like to open the floor to your comments and thoughts. Mr. Ghosh?
So this was sort of exactly what I wanted to address and why I wanted to sort of speak to it, because I think there's something, it's the way it's presented to us, and in these situations where it's approved one way as a renovation and then comes back to us again, it's not something we haven't seen before, but it creates these situations where it's very difficult to kind of visualize what's happened. But I tend to agree with the applicant here. From what I see, they got approval to build this home by the committee, and they are building exactly what they got approval for. And then the wall collapsed, and so now they need approval for the additional variances. They didn't need to consider depth previously because the existing structure already was at that depth. And I don't actually see the depth variance being 48 meters as being all that problematic, because depth, of course, is very different than length. Depth has to do with how far it is from the front of the lot. And because of the odd nature of this lot, the previous home was very far back there. And so I actually somewhat disagree, Mr. Chair, with your view. I think if this was coming to us as a new build, but they had given us the evidence that the previous home had been that far back there, we would have considered that and would have found that the depth still is minor, even though it's 48 meters, or at least that's the view that I probably would have come to. Even though the number looks very large, because the previous home had been in that location that made it that depth anyway, I think we would have considered that minor anyway, which is important to me, because we do have to consider the variances in front of us sort of freshly. So I think there was a home that was in that place. They did maintain the footprint, is what it seems like, but they did encroach on the ravine more. I'm sure that's true, the contention of the neighbors, by bringing what was I would call the first floor, but they're calling the second floor, down to the basement level. But that encroachment on the ravine was considered for the TRCA to give the permit for the original construction. And the way it's being constructed now has also been considered by the TRCA because they've been on site, they don't want a new permit. So I understand the neighbors being concerned about the ravine, but when ravine and natural areas for Toronto and TRCA both go on site and say there's no issue with the ravine, who am I to believe, the experts that say there's no issue or neighbors that are concerned? And so I really do view this as one of those cases of a bit of a much ado about nothing, where this was approved. It is the exact same thing, but because all the numbers seem very large, it's created a bit of upset in the neighborhood. So personally, I view it as approvable, and I also think, a 29-meter length, when you look at this in the neighbor context, the home is going to be the same length as most of the other large homes in this area of Rosedale. When you look in the neighborhood context, these numbers aren't actually that large. So that's sort of my explanation of what I think has happened and why I view it as approvable.
Thank you, Mr. Ghosh. Mr. Reid?
Thanks, Chair. I agree with Phil's comments. I think that there has been a missed opportunity here by the applicant in terms of not reaching out to the immediate neighbors and to the other concerned parties. There were a lot of concerned submissions that came in, and I think being a little more transparent and having a meeting and just explaining upfront what's happening, I think that would have gone a long way to helping people understand that basically what's happening now is almost exactly what was contemplated at the original approval. The fact that, as Phil said, TRCA and Ravines are on board with this and are fine goes a long way for me. And I think including the tying it to plans, I think would give some comfort to the neighbors and concerned parties that this won't be expanded any further. But I agree. I think that these are basically technical variances because it's basically what was approved before. So I'll be supporting it.
Thank you, Mr. Reid. Ms. Crawford, any thoughts?
Well, the TRCA no objection is kind of crucial for me, given the objection that was presented and the fact that was submitted by the applicant in follow-up question that they have recently reviewed as well. They've seen the new plans and they're approving, because I think that was probably the most significant issue, was encroachment on the ravine rather than the actual size of the house, which does seem to be comparable in the neighborhood. So under those circumstances, I think I can also support the application.
Thank you. And for my part, again, thank you, Mr. Ghosh, for the explanations, because I think it helps clarify my thinking. I think you're quite right that a lot of what we're seeing in front of us in terms of the variances were triggered subsequent to the accident, the damage, the collapse of the wall. And that's why they weren't there previously. So it's not a new request, it's an existing one. So I think it is supportable. I would like to, and Mr. Reid, your point about tying it to plans which came from the agent for the neighbors, I think is a very good one. That way we at least have some recourse if there's something amiss. Okay. All right. Thank you very much, everybody. I look for a motion. Mr. Reid?
Thanks, Chair. For the reasons we've discussed, I'll move up that we approve the application and that we tie it substantially in accordance with the site plan and all elevations.
Thank you. Do we want to add, just for the record, with regard to legalization? Or in this case, does it not apply?
I don't think it's necessary in this. I think because it's well documented the structural issues that they encountered, and I think they stopped right away. So I don't think it's necessary.
Okay, great, thank you. Do we have a seconder? Mr. Ghosh, thank you very much. All those in favor? Thank you. You have your approval, Mr. Podrick. Okay.
Through you, Mr. Chair, we have the agents for items 1 and 2 online now.
All right, bear with me a second while I find my Right. All right, moving on to back to item number 1. Item number 1 is 38 O'Hara Avenue. The purpose of the application is to alter the existing 2 1/2 story townhouse dwelling by constructing a rear 2-story addition with a ground floor deck and stairs and a front basement walkout. The existing rear ground floor deck and a portion of the existing front porch will be demolished. The committee had before it the following communication: copy of plan of survey, site plan, floor plans, and elevations, 6 photographs on the subject property, and we also have staff report from Urban Forestry. And just before we proceed, Madam Deputy Secretary Treasurer, I wonder if I might just speak to Mr. McKay for a second. Mr. McKay, I have ignored you, unfortunately. I keep looking to my colleagues here, but could I ask you to please interject when you have something to contribute, so that I don't miss you?
All right, thank you, Chair. I could interject with respect to this first application.
Yes, please.
It's a modest increase in building depth, a single variance.
Through the chair, so you have to read it into the record and then we'll circle back.
Okay, I'll read when you say...
Do you want a presentation or?
We not necessarily need a presentation, but I think it might be important to hear Mr. McKay's comments, and we didn't get his vote.
You mean for the last application?
For the last one, yeah.
I did vote on that.
Oh, you did? Okay. I'm sorry, Mr. McKay.
I voted for approval. Yeah, my concern had been the ravine, but TRCA was fine, so I voted with the majority there.
Terrific, thank you. We're good?
Through you, Mr. Chair.
Sorry.
Through you, Mr. Chair, we have the agent online for number 1 and no registered speakers.
Thank you. Good morning, Mr. Davidovich. Are you there?
Hi, yes, this is actually Robert Agivayev from GTA Permits, representing the homeowners for 38 O'Hara Avenue.
Your full name and address for the record, please.
Robert Agivayev.
And the address?
38 O'Hara Avenue.
Okay, thank you. All right, thank you for providing a very straightforward application after the more contentious one earlier.
Yep.
We don't have anybody in opposition, so we won't need a presentation, but let me just see if my colleagues either have a question for you or require a presentation. Mr. McKay, seeing none.
I do have some comments if you don't mind.
Well, we may not need them unless my colleagues would like to hear them. Nope, no.
No worries.
Yep, you're good. Thank you. It's a very straightforward application. The request is also fairly minor. So we'll take it into committee for a decision. Okay, would like to grab. Okay, please.
Well, I think Member McKay was.
Oh, Gary's there. Great.
Sorry, Mr. McKay.
Well, that's fine, Chair. Yes, I said it's just a single variance. It's quite modest in terms of the increase in building depth. So I would move approval of this application subject to urban forestry condition number 2.
Thank you. Okay, Mr. McKay moves motion to approve. Mr. McKay's got the first one. Mr. Reid seconds. All those in favor? Thank you. You have your approval, Mr. Sir. Thank you. All right, moving on to item number 2. Item number 2 is 204 Margueretta Street, and the purpose of the application is to legalize and to maintain the rear and side south roof canopy, which was constructed without an authorized building permit. There will be a total of 1 residential dwelling unit on this lot within the existing 2 1/2-story detached dwelling. The committee had before it the following communication: copy of plan of survey, site plan, floor plans, and elevations, 3 photographs of the subject property, covering letter from the agent, email correspondence from the agent, and building permit plans from the agent in an order to comply affecting the subject property.
Through you, Mr. Chair, we have the agent online and no registered speakers.
Thank you. Good morning, Mr. Ramirez. Are you there?
Yes, good morning. I am here.
Hi,
This
good
is John
morning. Let me just see if we don't have anybody in opposition from what I can see that requires you to do a presentation, but let me see if my colleagues have any questions for you. Any questions at this point? Mr. Ghosh has a question for you.
So it looks like the order to comply was from 2009. Has this condition been outstanding in non-compliance and outstanding for 17 years?
I was only brought into this onto this project a year ago, so I'm not too sure. I believe the structure does show that it has been there for many years, but I wouldn't be able to speak to that. Speak to that order.
Do you know why they're applying now? Like, is this, are the owners looking to sell the home and they're trying to legalize just in order to do that, or what sort of brought it on now?
Right.
To be honest with you, I would not know. I did not get any like history. I was just told to submit an application, and when I didn't even know about the order. I submitted an application for the canopies, and then we figured out there was an order. I didn't even look at the date to know that it was that long.
Okay, so you were retained just to legalize existing canopies. That's what you were hired to do.
Yes.
I think the variance that I have more trouble with than the canopy is the soft landscaping. So maybe you can speak to why 16% instead of 50 is reasonable here.
Yeah, I think the 16% instead of 50%, like the 50% comes from the lot width. All the adjacent lots or majority of those lots in those areas are less than 6 meters. Ours is 6.10 meters, so we're off by 10 centimeters. That throws us up into the next category of landscaping required, which throws us up to 50%. Whereas if we had 6 meters, we would have been at 25% required. And there is an existing garage at the back that takes up most of that soft landscaping. So in this regard, I would say this 16% is pretty common in this neighborhood. It's just those 10 centimeters that kind of throws us above into the 50% required soft landscaping.
So accepting your submission, I mean, that does make sense. It's just a few centimeters more and it makes it 50 rather than 25. But is there no way on this lot you could maybe make it 25 and that would be a more reasonable variance?
If you can just, I think the picture in the rear, you can see there is some green space. There's probably there's a walkway that we need to maintain. Yeah, right there, you can see the garden on the side there. The walkway we can reduce a little bit, but it wouldn't get us to 25%. You can see there's that width of walkway is we can probably reduce it down to 3 feet or 4 feet, but we do need access to the back of the garage, to the back garage, the existing garage.
I mean, it seems to me you could probably reduce that walkway easily by half, and that might get you to 25% if what's there is 16. But
oh wait, can I take a look at the site plan? I think we did do that. I think we did provide, or yeah, you can zoom into. There we go. Oh no, we don't. So Yeah, we could reduce that walkway, but I don't think it's gonna get us to the required 25%. Existing concrete pad and then soft landscaping, and it probably get us close to it, but it won't give us the full 25%.
Okay, those are my questions.
Just on that point, if I may, since you are suggesting some mitigation, would you be able to provide a percentage and a square meterage for mitigated soft landscaping?
Yeah, I can do a quick calculation here. I don't know.
That would be great. I think that would go a long way to in terms of looking at this application.
Okay, let me take a look here.
It seems to me that there's an area between the existing soft landscaping and the garage. So if the soft landscaping were extended by whatever that space there is, that might certainly make a difference.
Yeah, I think there's a door there.
Oh,
What I could do is propose like just a walkway of 3 feet wide to reach the back of the garage, to reach the garage, and the rest to be soft landscaping. I wouldn't be able to do the calculations right now because I don't have access to the I guess our AutoCAD software to do all the correct calculations.
I just want, Mr. Reed?
Yeah, well, thanks, Chair. My suggestion, what if, just looking at the site plan, it looks like there's enough room if you kind of doubled the existing open space that you have, either right up against it or on the other side, just eyeballing it, it looks like that would work in terms of providing a pathway to the back and leaving all in the front, the face of the garage paved as well to provide for door access. And it might be easy to just do the calculations by just doubling what you're proposing.
Well, then we wouldn't need the variance. Oh yeah, we still need the variance because we need to.
Okay, well, and so given that doubling would exceed 25%, if we want to agree that 25% is reasonable, maybe you could just calculate 25% pretty easily.
Yeah.
Okay.
So if you could calculate what 25% would mean in terms of square meters, we can give you a minute to do that.
Sure.
Mr. Ramirez, if you're having difficulty with calculations, would you like us to hold this application down for a couple and then come back to you?
Oh no, I did the calculation.
Okay.
So we would need an additional 11.05 square meters to come up with this with 25%, because the 25% would require us to have 30.76 square meters, whereas we're at 19.71 square meters. So 11.05 square meters would bring us up to 25%. Let me just redo that calculation. Or did you want me to go on hold and come back?
Through the chair to the agent. So for the record, you are seeking to amend variance number 2 with respect to soft landscaping. So we will need the new percentage as well as the meters square. So the same way the variance is written right now, we will need your new amended numbers, the percentage and the meters square.
Yeah, okay. So
I think your numbers may be a little high. If you just look at variance 2, so 50% is required, which equals 58.9 meters squared. If you're doing 25, then you can just do 58.9 divided by 2, correct?
Yeah, that brings us to 29.45. That would be square meters. 29. So if I were to take, 19.71. So yeah, it would be 9.74 square meters that we have to add. 9.74 square meters. So 19.
We just need the full number of 25% equals what you said was 29.45. Is that, you're comfortable with that?
Yeah. Yeah, because we're adding 9.74. So 29.45 square meters would give us 25%.
25%. That's great. Are you happy with that?
Yeah.
Okay. So it'll be an amended application. So thank you. I think at this point we can take it into committee and look for a decision for you. Okay. Who'd like to run with this particular one as an amended? Mr. Ghosh?
So I appreciate the agent working with us. I thought the soft landscaping was deficient, and just because the condition has been existing for 17 years isn't a reason for us to approve it. In fact, I do feel like it's a little odd. So certainly this is one where, I'll move to approve it as amended. But I do think that we need to include in the, for the record, that we don't condone unauthorized building.
Thank you. Do we have a seconder? Thank you. Oh, sorry. Ms. Crawford first, Mr. McKay.
Oh, through the chair, Member McKay also
I
raised.
think I saw Ms. Crawford's hand go up. Sorry. Okay, thank you. All those in favor of the amended application? Mr. McKay, thank you very much. You have a unanimous approval. Thank you. Okay.
I have a technical issue. Can we take a pause?
Yes, certainly.
All right. Yeah, thank you, Chair. Okay. Thank you, Chair. Just, I'm back, just waiting.
Thank you, Mr. McKay. Very good. Okay, thank you. All right, we move on to item number 4. Item number 4 is 3239-3251 Dundas Street West, and the purpose of the application is to alter the development standards for the 11-story mixed-use building by increasing the maximum building height from 38.5 meters to 40.2 meters. The maximum projections of equipment and structures and the minimum building setbacks. This current application is necessitated to seek further approval from the minor variance decision A0985/24TEY application, a site plan control application file number 21251-865-STE04SA is currently under review. Committee had before it the following communication: a copy of plan of survey, site plan, floor plans, and elevations. Covering letter from the agent, a decision number affecting the subject property, presentation materials from the agent, site-specific zoning bylaw number and revised diagram. Number 3, commenting agency reports, email correspondence from Transportation Engineering, staff reports from Metrolinx and from Community Planning. We also have correspondence in opposition from 154 St. John's Road and materials in opposition from the same address, 154 St. John's Road.
Through you, Mr. Chair, we have the agent here in person and 2 registered speakers also here in person.
Wonderful. Welcome and good morning again, Mr. Ewens.
Morning, Mr. Chair.
Name and address, please.
Greg Ewens, I'm the agent of the application, 1423 Kingston Road. We're here today on, we're requesting some very minor additions to, as you mentioned, a previously requested or previously approved variances for a building at 3239 Dundas. It's an 11-story building. We were here before the committee about a year ago, where the committee granted variances for a series of built form changes, which increased rear setbacks, made the building less of a stepped building, more into a a typical mid-rise building, as you're seeing them more recently. We added 2 stories to the building. We're not requesting any more stories or any more floor space today. The changes before you were driven entirely by construction matters. So the variances are minor and technical in nature, and they result from the builder electing to change from a traditional poured-in-place concrete construction to a more modern modular precast approach. This expedites construction time considerably, and it also helps achieve a more sustainable level of construction. This is proposed as a TGS Tier 2 version 4 building, which is one of the few mid-rise buildings in the entire city that's able to meet that. I see the presentation's up, thanks to staff. There's a couple buildings in context. The rendering on the left side there, that's a 9-story building just across the street that's approved and under construction. And then you have some other Main Street type buildings in the immediate surrounding area. There's also a number of house form buildings. There's a church building across the street. It's an area that's undergoing a bit of transition. Next slide, please. As it is on an avenue in a mixed-use area, it's in a mixed-use zone. The city has recently undertaken changes to their avenue policies, intending to permit mid-rise buildings, which typically have a height of between 5 and 14 stories on avenues. Again, this is the building proposed at 11 stories continues to reflect the previous 11-story proposal. Next slide, please. Next slide. Here's a rendering of the proposal. Again, 11 stories. There's some wrapped mechanical space on the upper floor and limited mechanical space on the actual roof, along with a stair tower and access to amenity. It says 138 rental units here, but it's actually 127 now, but the unit mix, which is almost 40% 2- and 3-bedroom rental units, is the same. There are also some affordable units included in this as a condition of the previous approval before the committee. 28 vehicle parking spaces, 150 or so bikes, and indoor and outdoor amenity space in compliance with the bylaw. Next slide, please. These are the variances that were approved in early 2025 regarding adding the additional 2 stories, additional gross floor area, and the change to parking requirements. Next slide, please. Since the previous approval, we've worked with staff through the site plan control process. There's been a lot of back and forth, and through the detailed design of the building, it's continuing. The applicant is currently involved in excavation and shoring activities on site. Again, the changes that are being requested here, variance 1 specifically results from a more modern modular precast construction approach. And what happened with the design of the building is that because of this approach, there were a few centimeters added to each one of the floor levels throughout the building. And so this pushes the roof slab up by less than 2 meters, but 1.5 meters. But it also allows us to move the side yard setbacks in, and I'll show you that in just a sec. The other 2 variances relate to rooftop equipment, which was originally permitted at 2 meters. It's typically 5 or 6.5, depending on where the project. We're requesting 4, just so we can make sure we fit the limited amount of equipment on the roof we need to that is mechanical. Next slide, please. These are important slides. This really gives you a sense of the magnitude or limited magnitude of the change. The red outline shows the previously approved building. The blue outline shows what is being requested. You can see the side yards on both sides have been brought in. The roof slab is a little bit taller, and those pop-ups at the top are stair towers, so those aren't across the entire roof. They're just a small portion of it. Next slide, please. This is the side profile of the building, and you can see here we've increased the rear yard setback as well. The stair tower at the roof is not as wide. It's also set back more from the front and the rear. We've maintained the front setbacks, and as you can see, the floor level at the 2 step backs and the roof has increased marginally, again, as a result of slab thickness for each one of the floors below, contributing to the overall height of the building. Next slide, please. Here's a comparison between the previously approved zoning map and what we're requesting now. There's a little more detail on the one on the right, and that's primarily because the applicant's been through detailed design. They know where the mechanical space is going. They know how big the stair towers have to be. This was the subject of a lot of back and forth with city planning staff, who I note have no objections to the application. Anyway, just to conclude, the effect of this change is faster construction time, a more sustainable building, again, meeting Tier 2 of version 4 of the TGS. Shadow impacts are functionally the same as the previous approval that was considered by this committee about a year ago. And in our view, the requested variances are very minor and meet the 4 tests. Thank you.
Thanks, Mr. Ewens. Let me just see if my colleagues have any questions at this point. If not, we'll hold off. Yep, okay. Thank you so much. I believe we have two folks in the audience who want to speak to this, and you'll be able to provide some rebuttal. Thank you. Good morning. Can we get your name and address, please? Okay, thank you very much. Your name again?
Sorry, Teresa Barta, 154 St. John's Road.
Thank you.
I reside immediately on the south side of the construction site. So the initial application of 3239, 3251 development has been submitted in December 2021 when rezoning has been approved in line with current norms and regulations. It listed 8 stories, 88 units, 71 parking spots. Incrementally, minor variances were submitted in April and June 2023, and now May 2026. And we have arrived at 11, if not 12 stories, 107 units, 54 parking spots. This cannot qualify as a minor variance any longer. None of these changes are driven by the site conditions and could not have been accounted for in the original architectural plans. It is evident that all these modifications presented as minor variances were just deployed to obtain a major rezoning without the due process being undertaken. The several rezoning applications have been approved without ensuring compliance with the legal requirements, such as subsequent shadow, wind, overlook, and privacy studies for the final configuration for an 12-story building. It is in our view that these cumulative changes constitute a material deviation in requiring full council reviewing. You are misleading the public by allowing a development that has incrementally applied for minor modifications, but whose cumulative effect is 25 to 37% taller building with 21.6% more units was never been publicly reviewed. Residents were consulted on one building, another building is being built. And I would say without consideration to the neighborhood. There is no further study of the shadow, no further study of the privacy, and what has been presented today as minor, in our view, it's a major increase in the height of this building, adding more units to the benefit of the development of the developer. So this is what I had to say in front of you today. Thank you.
Thank you. Let me just see if my colleagues have any questions for you at this point. Seeing none, Mr. McKay? No? I just have one question for you. I was just looking at your address. You're south of the
Yes, indeed. My fence is the fence of the backyard is
facing this.
It's neighboring the site. It's actually close to the site.
And just a question: how would the new construction or the current request impact you? I know that you've got a tall building coming up behind you, not tall, but it's certainly
I think it's impacting the shadow and also the privacy.
But you're south.
Yes, I'm south, so doesn't matter. It's taking the whole skyline. It's taken away, and also, height. It's impacting the privacy of this backyard more so than previously.
Okay.
And it's sorry. Yeah, sorry. Anyway.
Well, thank you so much. We'll have the agent respond to your comments as well.
Thank you.
Thank you kindly. Do you have anybody else as well?
Through you, Mr. Chair. I believe the speaker from 3237 Dundas Street West has left.
Yes, I said.
So there are no other
It was my
speakers.
neighbor who had to leave.
Oh, he had to leave. Okay,
sorry.
thank you.
Thank you.
Okay, we'll have Mr. Ewens come back. Thank you, Mr. Ewens. You heard the lady who just did a deputation earlier, so I'll leave it to you to respond.
Certainly. Thank you,
Thank
sir.
you.
So as I noted in my presentation, there was a previous committee approval from last year which increased the building height by 2 stories and approved a building largely as is proposed today with the very minor changes that I've shown in the diagrams in my presentation. We had a public meeting for that building on January 31st, 2025. That included a mail drop to everybody on the block as well as on the north side of the street in the surrounding area that actually went beyond the 60 meters normally required for committee notice. A number of residents showed up at that meeting. The local councillor was there, planning was there. So we have had a meeting on that previous building, and we made a couple of changes following that meeting as well before we were at committee. Again, I look at these as very minor changes driven by the necessary construction that will help us meet Tier 2 of the TGS V4. I think one of the issues here, and I'm happy to chat with the previous speaker, my client, the builder's here as well, so we're happy to chat after the item, is the city's AIC, the Application Information Center, doesn't maintain variances for very long after they've been approved. So a lot of the information that was included in the previous speaker's presentation is publicly available because it went through council and that stays online effectively forever. But variances that have been sought and approved, even within a year, tend to fall off the AIC. And I mean, I have been challenged by that in the work that I do, but certainly from a transparency and a public information perspective, it would be extremely helpful if there was a bit of a longer lead time on the AIC for these previous decisions to be available. If you Google that, you're only going to see the previous 9-story approval and the staff report. You're not going to see the decision that this committee made a year ago. That's all I'll say. Thank you. Happy to answer any questions.
Terrific. Thank you, Mr. Ewens. Let me just see if my colleagues have any questions for you. Ms. Crawford?
And you had a shadow and privacy overlook study done as part of this, not this application, but when was the shadow and overlook study done?
Yes, we submitted a shadow study in the 2025 application. And the change, we ran a shadow study as part of this, and the change was so minor so as to actually be somewhat confusing because the difference in shadow was almost not able to be discerned at certain points of the day because of the very limited change to the envelope of the building. We worked with staff on this and we elected not to submit it as part of this, but it's functionally the same shadow impacts previously that were supported by staff. In terms of overlook and privacy, well, it is a minor thing. I do note that the previous approval from 9 to 11 stories stepped the back of the building back quite considerably from the rear yard. It used to terrace down toward the south, the way you see older mid-rise buildings do. We increased the setback considerably from the back, and it's actually moved even further away from the back with this submission because of the new construction approach. So from a separation distance perspective, we're much greater than the required rear yard setback. We have effectively a tower separation distance, or greater than that even. I think it's over 20 meters in some instances from the rear yard. So it's considerable. And there's no projecting balconies also on the south side of the building. So that usually helps with privacy impacts.
Thank you, Mr. Ewens. Any other questions? Mr. McKay, any questions from you? None? Okay. Thank you, Mr. Ewens. We'll take it into committee now, look for a decision.
Thank you.
Thank you. Okay, who would like to pick up on this one? Mr. Ghosh?
So I wasn't in the previous hearing where the 9 to 11 was approved, and there was a shadow study, and it was looked at pretty extensively. There was a larger contingent of the community here at that previous hearing, which makes sense because it was a much bigger deal going from 9 to 11 stories. Having made that decision as being minor, I view this one as quite small, even in comparison to that one. The diagram of the cross-section shows that it's pulled in a little and up a little. for constructability reasons, it's not increasing the density on the site. So I view it as quite minor. I do understand the neighbors behind objecting at every opportunity, because this is going to be a large impact on them. There's no doubt about it. But I think their concern relates to what was previously approved, and we did consider it thoroughly at that time more than the incremental. I don't actually see much of an impact on anyone from this incremental change for constructability reasons.
Thank you, Mr. Ghosh. Any other comments or thoughts? No. Thank you. For my part, I do see this as a more of a technical request rather than a fundamental quantitative change. So I think this is a supportable application. Okay, we'll look for a motion.
Sure, happy to move it.
Thank you, Mr. Ghosh.
Move to approve, and I don't believe there's any conditions.
Through the chair, previously Metrolinx did have conditions of the warning clause, and they have restated that that has not been addressed as of yet with the site plan and the minor variance application. Should you choose to include the warning clause again from Metrolinx, you can do so. If not, that is up to you.
Yeah, there was a notation that it remains outstanding.
If it's outstanding from the previous, they can follow up with that. I won't restate it.
Thank you. Okay, do we have a seconder? Thank you, Mr. Reid.
Right.
Oh. All those in favor? Thank you. Mr. Ewens, you have your unanimous approval. Thank you. And we now move on to item number 5, which is 2151-2153 Gerrard Street East. And the purpose of the application is to construct a new 4-story, 16-unit apartment building with a front porch with stairs, the side west pedestrian ramp, and rear and side east, second, third, and 4th-story balconies. Also to construct a new side east 1-story detached ancillary building, garbage bin storage, and mechanical room. And there will be a total of 12 vehicular parking spaces and 13 long-term bicycle parking spaces provided within a 1-level below-grade garage with rear south access from the laneway. Committee had before it the following communication: copy of plan of survey, site plan, floor plans, and elevations, revised site plans, floor plans, and elevations, red line public notice, 8 photographs of the subject property, covering letters from the agent, arborist report, presentation materials from the agent, and then we also have staff reports from Metrolinx and Transportation Review. And we have correspondence in support from 20 Norwood Road and 22 Swanwick Avenue. We also have, 10 form letters in support signed by owners and occupants of 6, 9, 21, 23, 26, 27 Swanwick Avenue, 11 Costain Avenue, 45B Ben Lamont Avenue, and 48 Enderby Road. We have correspondence in opposition from 26 Norwood Road.
Through you, Mr. Chair, we have the agent here in person and 2 speakers here in person in support.
Here. Mr. Galbraith, hi, good afternoon. Still good morning, thank you. Welcome, and name and address, please. It should be on. If,
there we go.
Yeah, excellent.
Fantastic. Thank you very much. Nice to be back in the big room. I've been here since
improved.
pre-COVID. Sean Galbraith, planner here on behalf of the application, 18 King Street East, Suite 1400, Toronto.
Thank you. Before we go any further, since this is a redlined item. Can we just go through the whatever changes are being made?
The change is very simple. Based on discussions with Transportation Services, we were able to add 2 additional short-term bike parking spaces in the underground garage. And so the previous variance was for 0 short-term, and we've able to improve that to 2, where 4 are required.
And that's variance number 16, I believe.
Correct.
So we'll just add 2 there. Thank you. And that's the only change that's before us.
That's the only change to variances. We also had additional discussions with planning staff over the last week, and those resulted in a May 4th set of drawings. The 2 changes that were reflected in those set of drawings, one was the addition of a wheelchair lift in the front, replacing one of the front staircases, and privacy screens on the east face of the east balconies in the southeast corner there.
And that's reflected in the revised plans, I take.
Reflected in the revised plans, and staff references them in the staff report. So should you seek to tie to plans as staff requests, we have no issue with that. And they would be the May 4th drawings.
Thank you. The only conditions I can see are transportation planning and Metrolinks. And
Standard conditions. There'll be the transportation one is a rear lane widening, which we're aware of and we have no issue with.
Thank you very much. Since we do have folks in opposition, I wonder if we
think
could
we have
have
folks
your
in support.
Oh, they're in support? Oh, okay, sorry.
Yeah,
I thought
from
they were-
20 Norwood, I believe.
Beg your pardon.
A surprising amount of support, frankly, for this project, which I was very, very happy to see.
Thank you.
I think it reflects the appropriate scale of this project. We just as an aside, we first started talking with staff about this project back in 2022 or 2023, and at that time, this would have triggered a rezoning application, maybe an OPA, and site plan, and now it only triggers minor variances. It's within a PMTSA, it's on an avenue, it's on a designated major street, it's only 4 stories, and it doesn't even trigger a site plan application anymore. So I think it's very reflective of the change that the city is looking to achieve in small-scale apartment buildings, and I think it's a pretty great little building.
Thank you, Mr. Galbraith.
Through the chair to the agent, just for the record, with respect to the transportation review conditions and the conveyance to the city, you stated you were accepting of the condition, so you're confident that there's no variances that will be triggered or impacted as a result of that conveyance?
Good question. We've reached out to the zoning examiner to confirm. We haven't gotten a good answer yet. If it does trigger additional variances, we understand that that's in the realm of possibility, and we would come back to tweak it.
And that's the agent's responsibility. Yes, thank you.
Absolutely. Yeah, we have no concerns with that. We understand it. We know it's a risk, and we're fine with that.
Thank you kindly. Let me just see if my colleagues have any questions or require more detailed presentation. None. Mr. McKay, you're okay?
Yes, fine, Chair. Yeah, no questions. Thank you.
Thank you, Mr. McKay. Okay. For my part, I think this is a good project. And to your point, I think projects like these are becoming more acceptable and supported by the public at large. So it's a good sign. Thank you.
You're welcome.
We'll take it into committee now. And
through the chair, the speakers.
I thought, again,
our neighbor came all the way. We'd love to be able to hear her.
Speakers in support. Thank you.
There are 2 of us, but you didn't call us.
Hi, good morning.
I'm trying to follow your rules. Good morning. My name is Monica Schmidt. I represent 20 Norwood Road and 23 Swanwick Avenue, as both are my property of sorts.
And you're here in support?
In support.
Oh, okay. Well, you have 5 minutes.
Thank you.
Hear your piece. Thank you.
So good day, members of the committee. Thank you for this opportunity to speak. I'm a lifelong resident of this neighborhood around 2151 and 2153 Gerrard Street East, a community organizer, and I am a scientist. I grew up in the home where I have returned to raise my own family while caring for my parents at 20 Norwood Road, a property that's been in our family since 1967. My parents recently renovated this home for accessibility to age in place. Their home and garage stand to be the most directly impacted by this construction. Usually, a proposed 4-story building next to a 60-year family home draws fierce opposition, especially from the community organizer who, after watching today, is one step shy of starting a residents' association. Today, however, you are hearing the opposite. This project must move forward. It is a model of the city's guide to being a good neighbor in real time, a guide I just discovered. Due to the proximity and impact of the proposed build, we have shared many discussions with the builder and are well aware of the variances requested, which we accept, and in particular, the proposed balconies facing our property. We find them to be no different than windows, which have the same effect on privacy, but windows and, frankly, privacy screens limit the opportunity to engage in an open-air neighborly chat. Choosing to live in Toronto means acknowledging that you may have very nearby neighbors, and that's not always a detractor. One can lean into that regular source of socialization, which I do regularly, and this is particularly important for those who may find themselves more homebound than in years gone by. Our neighbors are our friends. We care for each other, and we intend to welcome and integrate our new neighbors into the community. This brings me to our community, a group of vibrantly engaged neighbors who want to support urban intensification that is responsible. I have shared and discussed this application, as my letter outlines, through a number of social media channels and emails. In contrast with item 3 today, the builder has further invited all neighbors to meet, call, or email to foster collaboration with the neighborhood. To my knowledge, nobody has done so, but this is presumably because people tend to invest their energy where they disagree. Now, in a neighborhood currently overwhelmed by aggressively large proposed new builds, this application has received, by contrast, overwhelming support that accepts the variances requested for 3 specific reasons. First, it proposes family-sized units. The proposed build represents a meaningful intensification with homes for long-term neighbors not passing through tenants for whom this would be but a starter home if it was a micro-unit. Second, at 4 stories, this proposed build offers gentle density in alignment with the physical streetscape and offers a sensitive transition without looming over the street or overshadowing the public park, which we all love dearly, to the rear. And this is a crucial point of support for ourselves and all others who have written in and to those whom I've spoken. Third, crucially, there will be minimal adverse effects related to street parking thanks to the underground garage that is slated to have its entrance directly beside my parents' garage at 20 Norwood Road. I cannot overstate this point sufficiently. All community members with whom I have spoken have stressed the importance of not creating further parking congestion, and we specifically support this building because of that parking garage. Now, beyond the immediate benefits of this building, I wish to offer, in the minute and 30 seconds I have left, a perspective from my professional work in clinical research, where I focus on bridging structural barriers to health for equity-deserving groups in our city. Ontario's population of people over the age of 75 will more than double by 2037, per the Canadian Institute for Health Information. As we pivot in healthcare towards an aging-in-place model, much like my parents have, we must look at what actually sustains independence for people of advanced age, seniors. According to the July 2025 Statistics Canada report, the 2 primary predictors of independence for seniors are home accessibility and the ability to drive. Seniors who lack accessible parking or lose the ability to drive are significantly more likely to require home care and community supports, further burdening our healthcare infrastructure. By providing a full level of underground parking and 3 distinct accessible entry points, the builder is not just building apartments, they're building a framework for long-term independence. The bulk of my work focuses on accessible design, in my case in healthcare, but I've learned a bit recently preparing for this meeting today about accessible home design. And this proposal engages in what we call universal design, treating accessibility as a philosophy rather than a checklist. It balances the needs of all life stages, a parent with a stroller going to the park via the laneway, a teenager desiring independence through their bike, a senior or a person with differences in mobility who relies on accessible units and a vehicle for their activities of daily living. It acknowledges that what works for one may not work for the other, but through multi-generational and accessible design, it creates a space usable by everyone, challenging the ableism inherent in most architecture. I have 5 lines left. If our collective goal for densification is to support a high quality of life for all members of society, we must practice intersectionality and have the power to do that. We can not only look at increasing front doors as expediency, we must consider the long-term ramifications through the lens of health and equity. It seems to me that the property owner and builder have put conscientious design before pure profit. This build will be welcomed by a tight-knit community of neighbors, and I respectfully urge the committee to approve it. Thank you for your time and the extra time.
Thank you very much. It's not often we get such enthusiastic support for some of the applications, but thank you so much.
You're welcome.
Let me just see if my colleagues have any questions for you, any comments? None? Thank you. Thank you very kindly.
Thank you.
Thank you. Do we have one more person?
Through you, Mr. Chair, yes, there's one more speaker from 20 Norwood Road.
That's me, because I represent me and my parents.
Oh, okay.
Hi. Yes.
All right.
Thank
So
you.
we're-
I got 10 minutes. Look, I did it under time, you guys.
Thank you very much.
Can you listen to that once again?
So through you, Mr. Chair, just to be clear, there's no more speakers.
Wonderful. Thank you very kindly. Mr. Galbraith, you don't have any need for a rebuttal, so I think you're okay.
I swear I didn't write that myself. I agree. Yes.
We'll take this into committee and
Thank you.
look for a decision for you. Thank you. Okay, folks. Mr. Reid?
Thanks, Chair. Yeah, this is an unusual application in that the level of support or non-objection for such a significantly sized building is not what we usually see, right? And I think that that goes back to the applicant, and we heard about their actions in terms of advancing this file. And as the agent stated, I think the planning framework really has changed in the last few years. This is something that would have been a very differently received application just even a few years ago. So I think that this is really nice to see a modestly scaled and sensitive kind of new evolution of an avenue apartment building in this neighborhood. And I think it's extremely supportable.
Thank you, Mr. Reid. We have a second. Mr. Ghosh?
So I agree. And I think that this is a modern take on the sort of 4-story walk-up apartment housing that we still see in our neighborhoods, but hasn't been built since the pre-war period. So to me, I see this as a model moving forward, and it is really refreshing to see it not have that much opposition. I say not that much because we do have correspondence and opposition that sort of lists the types of complaints that we would normally hear of just being opposed to density in general. I would say, though, that so firstly, good on the applicant doing their neighborhood outreach. That's probably part of why we see less opposition here. But also, there's a bit of chance to it that, different people see different applications and respond to them differently. And so I just want to say to the member who appeared in person that it was very refreshing to have that perspective, in that it would have been even more valuable if this was an application where we had a lot of neighbors opposed, and that easily could have been the case. And so I'd encourage her and people like her to continue to come out, because it is much harder to rally yourself in support, as she says. Okay, so those are my comments. I'm happy to move it unless any thoughts.
I just second those thoughts. It's got such strong neighborhood support. They're replacing a derelict building. It's an appropriate scale, family-sized units, parking. It's gentle density, as the point's been made. So yeah, I think it's a very supportable application.
Thank you. Mr. McKay, any thoughts? Any contributions?
Sorry, Chair. I know I agree with the comments. Wonderful to hear such support. So I'm certainly on board for this. Yeah.
you. Okay, do we have a motion? Mr. Reid, we'll run with yours.
Sure, thanks, Chair. So I'll move approval of the application as amended. That's with variance 16 improved to 2 bike parking spaces, short-term bike parking spaces, and subject to the transportation conditions and the community planning conditions.
Excellent. Do we have a seconder, Mr. Ghosh? Thank you. All those in favor of the amended application? Thank you. Mr. Galbraith, you have unanimous approval. Thank you kindly. Okay, moving on to, thank you very much. And we move on to item number 6. Item number 6 is 10 LaSalle Boulevard. The purpose of the application is to construct a new rear 2-story detached ancillary building, containing 1 garden suite with basement below and a side east covered porch, also to reconstruct the parking pad abutting LaSalle Boulevard. There will be a total of 4 residential dwelling units on this lot, 3 units occupying the main dwelling and 1 unit occupying the ancillary building. Committee had before it the following communication: a copy of plan of survey, site plan, floor plans, and elevations, 4 photographs of trees on the subject property, presentation materials received from the agent, and staff reports from Urban Forestry.
Through you, Mr. Chair, we have the agent online and no registered speakers.
Okay. Hello, Mr. Evangelista, are you there? Good morning.
Good morning, Mr. Chair, members. I'd Evangelista on behalf of the owners of 10 LaSalle Boulevard.
Thank you very much. Ms. Evangelista, we don't have anybody in opposition. And from my perspective, you've got 5 variances, which don't really have any issues. There is a forestry memo, but no forestry conditions. I think let me just see if my colleagues have any questions for you or would like a presentation. If not, we'll take it into committee.
Okay.
I think we may have one question for you from Ms. Crawford.
Yes, just following up on the urban forestry report that they talk about the location of the garden suite might injure the neighboring tree.
Through you, Mr. Chair, I would just like to address that. So we have been in communication with forestry. We have come up with an alternate, we've come up with a resolution to their comments. I would say the west corner, on the west side, kind of northwest corner, we are going to bring that back in the basement ground so that we do not encroach the roots. We are, obviously, we are going to maintain that tree. We did have an arborist come out on site and made those recommendations. So that northwest corner, we're going to basically square off that corner and then use a helical pile or pier in that corner. So right now, it is with forestry, and as we know, we will need forestry's approval to be able to get our building permit. But that is, and then we are outside of the tree canopy for that particular tree. So we have addressed it.
Thank you very much.
I have shared, my apologies.
No problem. Please go ahead.
I did share, albeit it came in late, I did share a rendering of what it would look like, in the basement section with staff. It's not in this particular submission because the submission was done last week, and we have just been in communication with forestry as of late. So there it is, and that's it. And this is what we're proposing. So that takes us out of the tree canopy. It preserves the tree, and we'll put a heli pier there in that northwest corner.
Is this part of a revised drawing that you're presenting?
This is
wondering if this becomes an amended application or not.
No, it does not, because this is just the basement portion.
Oh, I see,
So
okay.
yes, so all variances remain as is, but just so that we are preserving that root system, we are going to just bring in that basement portion of the structure. So it does not change any variances. We do want to preserve the tree, and we're doing everything that we can to do so. And as I mentioned through you, Mr. Chair, Member Crawford, we do have to get forestry approval to be able to move forward to get a building permit.
Excellent. Thank you very kindly. We'll take it into committee now and look for a decision. Yeah. Okay, who'd like to run with this one? Ms. Crawford?
I would move to approve the application. It's a corner lot and it seems to be appropriate development. And the variances are minor. My main concern was the tree, and urban forestry's suggestion to maybe defer so they could work with urban forestry, but that's already taken place and the issue's been resolved. So I would move to approve this application.
Thank you, Ms. Crawford. Do we have a second?
Through the chair, there is an urban forestry 2 condition.
Urban forestry
is there 2? Okay.
Yeah.
Yeah. Urban forestry 2. Thank you. Do we have a seconder? Sure. Mr. Ghosh, thank you. Oh, sorry. Mr. McKay beat you to it. Sorry, I didn't notice. Thank you, Mr. McKay.
Yeah.
Okay, all those in favor? Ms. Evangelista, you have a unanimous approval. Thank you. Okay, and move on to item number 7. Got me. Item number 7 is 353 Monarch Park Avenue, and the purpose of the application is to alter the existing 2-story detached dwelling by converting the integral garage into habitable space, also to permit a front yard parking space. Committee had before it the following communication: copy of plan of survey, site plan, floor plans, and elevations, 2 photographs of the subject property, and we have comparable decision numbers affecting properties at 276 Monarch Park, 71 Leroy, 3 and 25 Bonnie Bray, 875 and 890 Coxwell, 19 Northridge, 371, 373, 380 Salmon, 132, 151 Queensdale, 34 Kimborne, 435 Mortimer, 1021 Greenwood, and 82 Springdale. We also have email correspondence from Transportation Review and Development. We have Urban Forestry staff report, and we have support, 4 form letters in support signed by owners and occupants of 352, 355, and 360 Monarch Park. 351 Monarch Park.
Through you, Mr. Chair, we have the agent online and no registered speakers.
Thank you. Mr. Monteleone, are you there?
Good morning, Mr. Chairman and committee members. My name is Agustino Monteleone.
And your address, please, Mr. Monteleone?
1500 Royal York Road, Unit 48, in Etobicoke.
Thank you very much. We don't have anybody in opposition, so we don't really need a presentation from that perspective. We have before us essentially 2 variances, which both seem fairly minor. Let me just see if my colleagues have any questions for you. Mr. Reid has a question for you.
Thanks, Chair. The variances to me look like they're contradicting each other, right? So the first variance says you're locating your parking in the front yard, and then the second one says you're not providing parking. From your drawings, it looks like the parking space is fully located on the property of the owners. Is that right, or can you explain that? What seems to be a difference between those variances?
Yes, so the parking spot is going to be entirely located on the existing driveway, which is fully located within uh, within the owner's property. However, the variance here, from speaking with the zoning department, was that because the legal parking space was for this property is considered to be within the garage, um, and now that's going to be converted into livable space. So they're not considering this to be a legal parking space necessarily. But this is where the owners have been parking for years. They only have the one vehicle, and they're not looking to change that at all.
Okay, so it sounds like it's a technical interpretation of the parking, the shifting parking space. Okay, thanks.
Thank you. Any other questions, any thoughts? None, Mr. McKay? Oh, okay. We'll take it into committee and look for a decision. Okay, who wants to run with this? Mr. Ghosh? Okay.
Thanks for asking the question, member.
Sure.
It hadn't really occurred to me how conflicting those are, and I think they are. But the zoning examiner has decided on those two, and we don't have opposition from transportation or even a note from them that this one will need an application for a front yard permit. So given those things, I think we can take at face value that the parking will be acceptable. I've seen some others of these where people don't do what I will say is, I think, the right thing and backfill to the basement. And I've, in fact, had trouble with that in the past. Here, they're proposing to do that. You know, these basement garages are not the most ideal condition and aren't really approvable anymore, and they're converting back. The variances are very minor and not impactful to the neighbors. I think it's improving the condition. So for those reasons, I'd approve it, subject to Forestry 1.
Thank you. Do we have a seconder?
I second
Mr.
that.
McKay. Thank you, Mr. McKay. Okay, all those in favor? Thank you. You have your approval, unanimous approval, sir. Thank you. Moving on to item number 8. Item number 8 is 6 Park Vista, and the purpose of the application is to alter the existing 10-story apartment building by converting the second floor laundry room, the third floor storage room, and locker rooms on the 4th through 9th floors, all located on the south side of the building, into 8 residential dwelling units. Also to convert the ground floor storage and mechanical room located on the south side of the building into a laundry room with a maintenance area. No indoor amenity space will be provided. There will be 5 short-term bicycle parking spaces and no long-term bicycle parking spaces provided. 4 lawfully existing tenant parking spaces will be converted into 3 visitor parking spaces and 1 accessible parking space. There will be a total of 116 residential dwelling units and 123 parking spaces on this lot. The committee had before it the following communication: copy of plan of survey, site plan, floor plans, and elevations, 3 photographs of the subject property, Toronto TRCA permit number. We also have email correspondence from Transportation Review and staff reports from Ravine and Natural Features, Urban Forestry, and from the planner at TRCA. We also have correspondence in concern or interest from 811-6 Park Vista. And we have opposition correspondence from somebody with no address provided.
Through you, Mr. Chair, we have the agent online and 3 speakers in opposition in person.
Thank you. Good morning, Mr. Pomeroy. Are you there?
Yes, good morning.
Hi, good morning. We do have folks in, sorry, if I could just get you a full name and address, please, for the record.
Yes, sorry. Good morning. My name's Scott Pomeroy. I'm the applicant and architect, and my address is 713 Gerrard Street East in Toronto.
Thank you very much. Since we do have a couple of folks in opposition, we will require a presentation, please, and you have 5 minutes.
Okay, great. Yes, so as you've just explained, the proposal is to add 8 units within the existing 108 unit apartment building. These will be located as mentioned on the south side in what is an existing laundry room, and on the second floor, and then in storage rooms above that. In order to do that, there is a maintenance room on the ground floor that we are converting to the laundry room. We have space for that. And then would proceed with to apartments above that. These buildings are maybe not unique is the right word, but they were originally developed without the ground floor is limited to the area around the entrance lobby and elevators, etc. And then they have outdoor covered but outdoor parking underneath the residential wings. So they are short on space on the ground floor, and they don't have basements. So for I guess, i.e. for we don't have a lot of amenity space or space to turn into amenity space. That said, and I should say that the owner did do a consultation with the residents and presented this to them. I wasn't in attendance for that, but the feedback they got was asking if they could put more laundry equipment, more washers and dryers in if possible, which they will do. And having just, we saw the letters of objection came through the last few days. And so in looking at that, as I said, I don't know if you can go to the slide of the laundry room on the ground floor or the page. That there was a concern for, I mean, obviously we'll go through them, but there were some concerns that I think were more to do with building construction in general and building permits, but there was a concern raised about just having a meeting space for the residents and the so in discussions with the owner, they're on the second floor space in the laundry area. There is additional space. It's approximately 100 square feet. So it's not quite what the 2 meters per unit would be, approximately 160, 150 square feet. But the owner is amenable to, in fact, was going to fix that up anyway. So would be happy to provide furniture in it for a meeting room to alleviate concerns of the objection, the one objection that was stated. So.
Okay. Thank you very much. Let me just see if we have a question for you from Mr. Reed.
Thank you, Chair. So just to clarify, are you saying that what's currently the laundry room on the second floor, you're intending on that is going to be your spot where you'll have this meeting room?
No, sorry, on the ground floor. So yes, that slide that you're looking at, so that's the proposed ground floor, and on the right-hand side of that space was left unprogrammed in this proposal, but that space could be turned into, they can put table and chairs and seating, et cetera, and make that into a small meeting space.
Okay, thanks. I understand now.
Thank you very much. Mr. Ghosh has a question for you.
So the one laundry room is being removed and a new one is being put in place. Can you speak to the number of washer dryers in the existing laundry room versus the one that's being put in place?
Yeah, they're equal right now. So there were 6 of each washer and dryer being taken out of the second floor. This is will be done at the same time that these are becoming stacked units. So now we've got 6 of each again in the proposed. But there is there is additional space that they can. That said, they discussed with the tenants that they'll look for. It looks like they can at least get another pair in, so they will provide that as well. But but as proposed right now, it's the equal space. There is some mechanical equipment below where we're proposing, so it looks like there's a large gap behind the washer dryer, but as you can see, the water shut off and there's a lot of pipe work back there, so we're not able to push it back all the way. However, across the way where there's a sink and millwork for the laundry room, we can take some of that space and add another stack of laundry.
Okay, thanks.
Thank you very much. Oh, Ms. Crawford has a question for you.
Yes, so sorry if I'm repeating, there were technical issues, but so the proposed new amenity space is right beside the laundry room?
Yeah, so just on this image that's up, just to the right, it's in this plan is unprogrammed. So again, going back to the overall key plan of the ground floor, the rest of the space is spoken for or is used for mechanical, electrical rooms, locker rooms. There's not. Yeah, it's just in that center space because then you can see all the covered parking to the left and right. So there's not really any space to other than this to provide. So, so that's why it wasn't originally proposed. But then there is extra space in the laundry room area. So we would have the ability to create like a meeting room in that location.
And how would that impact the variance? Right now, you're.
The indoor variance is 2 meters per unit added. So 16 square meters would be required. And this is approximately, I think, 8 by 10, 10 by 10. So we'd be around meeting about 60% of that.
You're 10 by 8 meters?
No, sorry. I'm sorry.
You went from meters to feet.
Thinking in feet. 3, I guess that's about 2.5 by 3 ish. 3. Yeah, so we would be approximately probably 8 square meters, something like that. So I guess about half of it.
Okay, any other thoughts? Mr. McKay, any questions, any thoughts?
I don't, thanks, Chair. No.
Okay, thank you, Mr. McKay. All right.
I have one other question, sorry.
Mr. Ghosh has a question for you.
Most of the other space that's being converted seem to be these sort of awkwardly shaped storage spaces. What is being stored in those right now? Is it given to tenants for free with their lease? Is it rented to tenants, or is it for the building?
So inside of them are individual locker spaces that are rented to tenants or would be part of their lease. Like, they're not in new leases. There may be some that are assigned to tenants that are legally theirs. So generally for these buildings, the building permits, like the owner doesn't go and develop all of them at the same time, and especially not if there are locker space, if, you know, they legally cannot take out locker space that tenants have the right to and is in their original lease. So they would either, you know, they can move them around if they need to from floor to floor, but they're largely underutilized.
Okay, thanks. That helps.
Thank you very much. We can move on to the folks in opposition now.
The speakers in person can come up to the podium.
Good morning.
Good morning.
Hi.
Hi.
You could just have your name and address, please.
My name is Mariana Lewecki, Maryanna, last name Lewcykyj. I am a resident of East York. I do not want to give my specific mailing address because of concerns. I've had my address used before for people applying for credit cards without my authorization and consent, and it was not a pleasant experience to try to get that resolved, and my understanding is it is not required.
Thank you very much.
Okay, so you started the clock,
you've
yes.
got 5
So
minutes
thank
to
you
go.
for the opportunity to address you under the residential apartment complex zoning bylaw 569/2013, chapter 15, 20, 40, 50, 1A. A building with 20 or more dwelling units must provide a minimum of 2 square meters of indoor amenity space for each dwelling unit. The notice for this application states that a total of 16 meters of indoor amenity space is required on site and no amenity space is proposed. The 16 square meter calculation is based only on an incremental allocation for the 8 additional units that are proposed to be added. However, the building currently has 108 units. If the current bylaw formula applied, it would mean 216 square meters of existing indoor amenity space. However, there is no existing dedicated indoor amenity area. This 108-unit apartment building is one of 4 rental buildings on Park Vista managed by the same landlord. The other buildings have 121 units, 84 units, and 56 units. None of them has an indoor amenities room. If the current 2013 formula applied, it would mean 738 square meters of indoor amenity space across the 4 buildings. The previous landlord, Caprit, had said that they had planned to convert space in one of the buildings into an amenities area. The plans were put on hold during COVID, and the building was later sold to the current owners. Allowing this proposal would effectively sterilize the building from any potential of amenities use and ability to meet the general intent and purpose of bylaw 569/2013 due to space constraints. Also, because 2 Park Vista and 7 Park Vista are also slated for more units, those buildings are also effectively sterilized for the purposes of amenity space. 4 rental buildings with a total of 369 units, with more proposed, do not have any indoor amenities rooms. There has been lots of research about the negative effects of loneliness and feelings of isolation, particularly among seniors, even in large, bustling cities such as Toronto. And third spaces, like amenities areas, are important to give people a place to gather and engage with others. An amenities room would also promote tenant well-being through activities such as wellness seminars, card games, or board games to boost cognitive activities. This would particularly be beneficial for tenants with mobility constraints who have difficulty getting to community centers or other gathering places. Finally, 6 Park Vista does not have central air conditioning, and there are restrictions on window air conditioners and units. An on-site amenities area with air conditioning could serve as a relief center during heat waves. I would encourage you to consider the negative impact of allowing a building with a proposed 116 dwelling units to have no dedicated indoor amenity space, contrary to the general intent and purpose purpose of bylaw number 569, 2013. If existing spaces at 6 Park Vista are to be repurposed, it should be an opportunity to better align with the mandatory measures around indoor amenity space. This could be done by leaving the laundry room on the second floor and converting space on the main floor into an amenities area and adding just 7 units instead of 8. Let's promote both innovation and integration rather than simply squeezing more units into a status quo that does not meet important tenant needs that were codified in 2013. Thank you for your consideration.
Thank you very much, ma'am. Let me just see if there are any questions for you. Any questions, any thoughts, Mr. McKay? Nope, okay. Thank you very kindly. We'll have the agent respond to your concerns. Thank you. Who's next?
Through you, Mr. Chair, the agent or the speaker at the podium is the next speaker in person.
Thank you very much. Name and address, please.
My name is Gail Mahone. I live at Unit 811 at 6 Park Vista. I have 2 major concerns with this variation being brought forward. My major concern is the plumbing issue. These buildings were built in 1966, and as we know, in 1966, lead piping was very prominent in buildings. We have had major problems with our plumbing ongoing. I've been in the community for 34 years. But recently, with renovations that are being done, we're having more and more water shutoffs consistently. By adding these units, we're adding to an already stressed system. And there's nothing that says they're going to go through the whole building and replace all the plumbing. That's a major concern. Plus, we also have, each time the plumbing is shut off, we have issues with the smell coming from the water when it's turned back on. And not for just a short period of time, sometimes days. So that's one major concern I have. The others, there is ongoing renovations being done in the building without visible building permits being shown to us in any way. So my concern is, if this adjustment is approved, what other renovations is this landlord going to do under the guise of your agreements? Because they're doing stuff now that they shouldn't be doing, removing walls and that. And what's to say they're not going to try to do more than what they're asking for? And that is my major concern. Thank you very much for your time.
Thank you kindly. Let me just see if there are any questions for you at this point. None? Seeing none? Okay, thank you. We'll have the agent respond to your concerns.
Through you, Mr. Chair, there's no other speakers.
Thank you very much. Ms. Pomeroy, are you still there?
Yes, hello.
Hi. You've heard the 2 folks that addressed the matter before us. I wonder if you might want to respond to their concerns.
Sure. I will speak to the latter one first, just to say that that is those concerns regarding plumbing and construction are really a building permit matter. And I mean, at least as far as I know, in my involvement with this owner, you know, well, I know they do everything on the up and up. We've applied for building permits for them, and there will be building permits applied for this work. And I don't think it serves their interests for plumbing not to work properly for their tenants. So that's more of a technical matter under a building permit to review. And obviously this minor variance isn't approving that portion of it, but we will go through a building permit. Regarding the former opposition, yeah, I just wanted to remind or mention these buildings, as I said, the original buildings were developed without a lot of ground floor space and due to the open parking, but they do have a significant amount of outdoor space and outdoor amenity, which is not a variance required, of course, because they have so much of it. But this is a group of buildings on Park Vista Drive, and each of them has either large areas of greenery, swimming pool, playground, etc. So I think the original intent of the design was more for the outdoor amenity portion, whereas we're limited on the indoor. So it's the proposal at hand is to add more units to the building. So we would like to maximize that and get the 8 units, and moving the laundry room to the ground floor, I think is a good idea. As more of a common area space. And not speaking to, obviously we can't tie other buildings into what we're doing at this building, and we want to deal with each one on an individual basis. But with the space that's available, as I said originally, that the owner is willing to provide, use that space as an amenity space. Appreciate that it's not as large as what would be required for the full, to meet the full current requirements, but I think is still is a usable space for the space that we have.
Thank you very much. Let me just see if my colleagues have any questions for you at this point. If not, Mr. Reed's got a question for you.
Thank you, Chair. I think that the first speaker made a good suggestion of maintaining the laundry room on the second floor, and then that first floor space that is going to be, that you're proposing to convert to a laundry room and maintenance area, having that whole thing as a amenity area. Would you consider that?
I think, it's as the applicant, I mean, the application, the owner obviously would like to get 8 units out of this. I can't speak to whether or not that, like, the space is not where we're putting the laundry space. It's going in front of a lot of, like I was saying, pipes and etc. It's it's definitely larger than the would be larger than what we're proposing, but so it's a little difficult for me to review it immediately and say, like, hopefully that meets that would have to meet the 16 meters. But also I don't want to speak for the owners about, taking off one of the units. So, and ultimately it's, they're it's always, it's to their benefit, but it's also to the city's benefit getting more units in. So I'm not certain. I don't think that's their, they would like to provide, put the laundry on the ground floor, which is better for the building, as well as provide this smaller amenity space.
Right. Okay. I understand you're representing your client. But I don't know, it seems like you have already made some improvements in offering some amenity space, but would a deferral make sense to you in terms of then maybe formalizing that a bit more or expanding that and having discussions with your client to have something that would maybe please the tenants and the ownership?
Can I speak to that? Yeah, Mr. Reed's suggestion would actually be really important for me to be able to support the application, because I do think the indoor amenity space is really important, as the neighbor spoke to, or the resident spoke to, and I don't think it's great. It's kind of small and beside the laundry room, And the outdoor space doesn't do it either because we have a hard winter. So this kind of change and perhaps a deferral to consider this type of change would certainly be something that I could support.
Mr. Ghosh, any thoughts?
Yeah, well, I would just say there, you know, a deferral would also, even for the amenity space that they do propose of a meeting room in that area, would let them show it on the plans, would let them calculate the area of that. You know, applicants are entitled to come and ask for what they want, and if they want to come back and ask for the all 8 units again, they could do that, but a deferral would still even let them sort of show the proposal in its best light, and consider whether to, you know, make the laundry, this entire ground floor area an amenity room, or maybe shift the laundry room and make the second floor laundry room an amenity space. You know, there might be different options. Would give them time to consider them. But if they don't want to defer, I never like to push a deferral on an applicant. I would consider it on its merits, and I have a conflicted view about this application, so we could speak in committee about it.
Mr. Pomeroy, just a question for you from me. Are you aware if whether the owners had any discussions or canvassed any of the tenants in the building about the
Yes.
proposed changes?
Yes, they did. They did hold a consultation, and I spoke to the planner about that actually, but the amenity space did not come up. It was not requested. The request that came out of it was for additional laundry machines.
I see. Thank you. Yeah, we don't have any other questions for you. Mr. McKay, do you have a question? Yeah, Mr. McKay's got a question for you.
Well, it sounds as if then we'd be varying variance number 1, which is essentially eliminating or not requiring indoor amenity space. But you've made some suggestions that I think should be pursued with the owners here. So I'm more in agreement with some of my colleagues here who say maybe it's best to defer the application until that amenity issue can be sorted out.
Thank you, Mr. McKay. Mr. Pomeroy, you've heard the comments from members. What are your thoughts about a deferral and coming back as soon as we have an opportunity to slot you in again?
I'm likewise conflicted, but because my feeling is yes, I've heard from the members, and sounds like there's unlikely to get that we need to defer in order to get approval for it. But I am conflicted because it comes down to, you know, the owner, it wasn't requested during their consultation. They are offering, you know, I appreciate that it's not full way, but I think they're doing pretty well for what the building offers and for what they want to achieve. So it ultimately comes down to what we're talking about one additional unit versus amenity space, and you know, what serves the public better. So I am conflicted, but having said that, I think also conflicted because I feel like if we proceed, that it may not be supported. So with that, I think we'll have to defer, and then we can at least have some time to take a look at it, and hopefully that we can get on it fairly soon into the next meeting. It won't take us long to take that back and see what's possible, and then hopefully get on to a meeting fairly quickly.
Thank you very much. I think you've made a wise decision. I think it's essentially variance number 1 that needs to be modified to some degree. So I think the deferral, the thought of a deferral, I think is quite appropriate. We do need to just speak to the folks in opposition just to get their sense of what they think about a deferral. So if I may just ask folks both to come up. A very simple question for you, and it's just a yes or no. Are you in favor of a deferral or not?
Very much in favor, with thanks to the committee for their consideration.
Thank you. And to you, ma'am?
Yes, very much so. Thank you for.
Thank you kindly. So we'll take it into committee, Mr. Pomeroy, and render a decision for you. Mr. Ghosh, do you want to run with this? Thank you.
Yeah, so I think had this gone into committee, I would have been conflicted because I can kind of see both arguments in that a lot of these residual spaces may not be the best amenity space. So maybe the best use of the space is an additional unit because the city requires that. But I also do agree that the concern about having good amenity space in a building is a real one, and so I think it's and I think panel members are right to express that as a concern. So I think the applicants have made a good choice in deferring it because they can speak about it. The agent can speak about it with his client and consider the pros and cons of coming back with more amenity space or not. But I think regardless, given that they have this empty space that they've already said they're going to convert into amenity space, why wouldn't you take the time to show that on the plans and improve, even if they come back with eight units, they'll have a much more supportable application to include even just that meeting room, maybe put a demising wall, whatever it is to make it, and also to reflect the additional washer dryer on their plans as well, so that they can say there's an improvement in a condition. So I think they've been very wise, and even if they come back with 8 units, they should show those improvements at the very least for the committee. So with those comments that I hope are instructive to the applicant's agent, I would move to defer.
Do we have a seconder?
Second that.
Ms. Crawford, thank you very much. All those in favor of a deferral? Mr. Pomeroy, it's a unanimous decision to defer. Thank you. Okay. And we move on to item number 9. Item number 9 is 794 Bathurst Street. Purpose of the application is to permit a nightclub use and eating establishment on the second floor of the existing 2-story mixed-use building containing storage uses within the basement level, 5 commercial units on the ground floor, and an existing nightclub and eating establishment on the second floor. The committee had before it the following communication: copy of plan of survey, site plan, floor plans, and elevations, 4 photographs of the subject property, authorization letter from the agent, planning rationale prepared by the agent, staff report from project manager, Night Economy and Economic Development and Culture. And we have correspondence in support from Mervish Business Improvement Area.
For you, Mr. Chair, we have the agent here in person and no registered speakers.
Thank you very much. Good afternoon. Name and address, please. Yeah. Oh, with green button.
Oh, sorry. Good afternoon, Chair and members. My name is Robert Bader, B-A-D-E-R. I reside at 38 Albany Street. That's in South Etobicoke.
Let me just, before you proceed, let me just see if my colleagues would like a presentation at all or not, in which case we can expedite.
Fantastic. I'm available for any questions.
Thank you very much. Mr. McKay, any questions, any thoughts? Yeah.
Sorry, yeah, just wondering why the need for the change to go to the second floor from the ground floor. What's happening? Is a lease up? What's just sort of wondering about what's behind the request.
Sorry, that's not exactly what's taking place. I think the description is a little bit verbose. It's describing the entire building, including the area that's taking place in the uses that are taking place in the basement, the existing uses at the ground floor. This is in respect of just aligning the existing nightclub that's been in operation there for some 30 plus years, located at the second floor, to align with the new provisions and new regulatory regime that the night economy has introduced.
Okay, I'll have to get out and about a little more since it's been there 30 plus years, but okay, thanks for this.
Would I be correct in saying that this is really a technical request?
Correct. Yeah, it's responding to the new regulations that have been imposed through the city's night economy regime.
Thank you. It's called elevating nightlife.
Well, recognizing it and understanding that it's it's an economic benefactor to the city, and it drives tourism and residents, and it's a commercial enterprise that should be positively considered.
Yeah, thank you very much. Any other questions? If not, we'll go into committee and render a decision. Okay, Mr. Ghosh.
Yeah, it's not the first one of these that I've seen. It seems like that by defining a nightclub, they've created some zoning challenges with this night economy that otherwise seems to be a good policy at the city. So to permit the existing nightclub to continue to operate there with this zoning change makes sense to me. The other thing I thought was interesting is I think it's the first staff report I get from Economic Development and Culture. So always interesting to see the different groups there are at the city. But I would move to approve it. I see what's the impact of letting this business continue to operate.
Thank you. Do we have a seconder? Mr. Reid? Thank you. All those in favor? Thank you. You have a unanimous approval. Thank you, sir. Thank you. Take care. Okay. We move on to item number 10, after which we can take a short break. Item number 10. Item number 10 is 11 3rd Street. Purpose of the application to alter the existing 1 1/2 story detached dwelling by constructing a rear 2nd story addition and a front barrier-free access ramp for the existing front porch. Also to permit and maintain the existing rear ground floor deck with a trellis and stairs. The committee had before it the following communication: copy of plan of survey, site plan, floor plans, elevations, revised site plan, red line public notice from the agent, 2 photographs of the subject property, covering letters from the agent, comparable decision numbers affecting the properties at 13 3rd Street and 3 Channel Avenue. Survey report prepared by Genesis Land Surveying, staff report from Urban Forestry, and a 10-signature petition in support, signed by owners and occupants of properties on Channel Avenue, 2nd Street, and 3rd Street.
For you, Mr. Chair, we have the agent online and no registered speakers.
All right. Mr. Hall, are you there?
Yes, I am. Can you hear me clearly?
Yes, we can. Thank you very kindly. Just a name and address for the record, please.
Daniel Hall, a principal architect with Sustainable Architecture for a Healthy Planet at 5.5 Luttrell Avenue in Toronto.
Thank you very much. Let me just see if my colleagues, there's nobody in opposition, so we won't require a presentation from that perspective. But
Through the chair, there is a red line notice if the agent for the record
yes.
can go through the amended variance and also speak to the purpose of the application, whether the purpose should be amended as well with respect to the front barrier-free access ramp.
Thank you very much for the reminder. What changes are being made to any of the variances, Mr. Hall?
So the variances all stand, but variance number 4 refers to 2 different components of the project: an existing rear deck that is to remain, and a proposed new front access ramp and adjustments to the front deck, which the owner has decided she will forego for the time being. This was planning for future, and if we need them in future, we actually decided we would locate them on the other side of the property. So we've removed them from the site plan. There is no longer a proposal to add an accessibility ramp at the front. Whether the description should be changed, perhaps it should as well. We were only asked to change to redline the variance, but I think you're correct. There's also reference in the description.
So is that variance number 4 that you're talking about that's being deleted?
No, it's not being deleted. To be very clear, variance number 4, as written by the plan examiner, refers to 2 different components. One which is existing, but does not comply with zoning bylaws. It's been there at least the 20 years that I've been aware of this property. And this, you see the way it's worded, it refers to 2 different things. The rear ground floor deck remains. We would still like to bring it into compliance with the zoning bylaw by means of this variance.
So I'm just a little puzzled as to what the change exactly is in either the wording or the numerical information.
Yes, well, there is no change in the actual variance being asked for. The purpose of the variance, which was to cover 2 different non-compliant conditions, now only covers 1 non-compliant condition. Okay. So we struck reference to the front ramp out of the wording.
All right, I think you've got it. Okay. I'm having a difficulty seeing it, but my colleagues have
Through the chair, the red line notice is on the screen. So the agent is amending variance number 4 to remove the crossed out section with respect to the accessible ramp structure only, but maintaining the rest of the variance that pertains to the rear ground floor deck. And then as a result, the purpose of application would be amended just to delete the portion that speaks to the front barrier-free access ramp for the existing front porch. We can strike that from the purpose and maintain the rest of the purpose as is.
Perfect. Thank you very much. Okay. Let me just see if my colleagues have any questions for you or would like a presentation. If not, we'll take it into committee. Mr. McKay, any questions, any thoughts? None?
None, thanks. I'm prepared to go into committee if the other members agree.
Okay, I don't see any requests for any questions, so we'll take it into committee. And Mr. Reid?
Thanks, Chair. I'm happy to move this. This is a very sensitive renovation and addition that's being proposed. And the island zoning bylaw that applies to the island in terms of the angular plane is quite complicated. So I wanted to thank the applicant for that axonometric drawing that they've included and showing the protrusions in a 3D way. That makes it really easy to understand. So I appreciate that. But I think what's being proposed has little to no impact on the neighbors. It's almost entirely within the as of right envelope. There's just small protrusions. So I'll move approval of the application as amended, with the purpose amended and the 1 variance amended, and subject to urban forestry condition 2.
Thank you. Do we have a seconder? Ms. Crawford, thank you. All those in favor of the amended application? Thank you. You have unanimous approval, so thank you. Okay.
Through the chair, perhaps we can take just a 5-minute break at this point, and we will resume in 5 minutes. Thank you. Members, mute. Okay, the room is muted. Thank you. Gary, we're back. If you're here, please turn on your video. Member McKay.
Yes, thanks, I'm back.
Thank you.
Thank you.
Okay, item number 11's already been deferred. So we move on to item number 12. Item number 12. Item number 12 is 155 Shore Street. Purpose of the application is to alter the existing two-story semi-detached dwelling, by constructing a rear second-story addition above the one-story addition and a partial third-story addition with a rear balcony. Committee had before it the following communication: copy of plan of survey, site plan, floor plans, elevations, revised site plan, floor plans, elevations, red line public notice from the agent, 21 photographs of the subject property, covering letter from the agent, presentation materials regarding the rear addition from the agent, email correspondence between the agent and community planning, and we have staff reports from urban forestry and community planning. We also have 3 signature petition in support signed by owners and occupants of 157, 167 Shore Street and 136 Crawford Street.
Through you, Mr. Chair, we have the agent online and no registered speakers.
Okay, item number 12. Good afternoon, Mr. Chanway. Are you there?
Yes, I am. Good afternoon.
Hi, good afternoon. We don't have anybody in opposition, so we don't need a presentation from that respect. Let me just see. First of all, this is a red line notice, so there's some amendments, presumably, some changes. Can you just identify what the changes are?
Yes, so if you turn to, I just want to say that Charles Conway, 20 Smithwood Drive in Etobicoke.
I'm sorry, I didn't quite hear that.
My name is Charles Chen Wai from 20 Smithwood Drive in Etobicoke.
Terrific, thank you.
And then if you turn to page A7A.
Just in terms of the variances that are presented in front of us, could you just tell us what numbers have changed, if any deletions?
So in item number 1, the wall width was 100% full width, and we've reduced the full width to 76%.
Okay.
And that's an improvement on that variance. And then item number 3, the existing owners of the property do have some flower boxes, and it increases the existing soft landscaping to, where's the numbers? We've increased the soft landscaping from 0% to 3.86%, so improving the variance of the soft landscaping.
3.86. Thank you. And those are the only changes, correct?
Correct. So this was due to some of the communication back and forth with the planning department, and now they're in favor of our proposal.
Thank you very much. Let me just see if my colleagues have any questions for you or require a presentation at all. If not, we'll take it into committee. And by the way, you are aware of a planning condition and a forestry condition?
Yes.
Perfect, thank you. Mr. Reed?
Thanks, Chair. I note that you've amended your variance 3, the rear yard soft landscaping, but it's still a very small amount. Is there any other way that you can improve that?
We could improve it by adding more additional flower boxes onto the rear yard to increase the percentage. Yes, we're willing to do that.
So what percentage would you be able to go up to if we were to amend that further?
Well, the minimum requirement is 25%, and As of now, we're at 3.86. I was wondering if 5% would be sufficient. So it'd be a 1/5 of the existing backyard would be, like, not the backyard, 1/5 of the minimum required would be soft landscaping.
Yeah, we can't really tell you if that's sufficient or not, but you can make your amendment and then we'll discuss it. But I'd just say do your best, and if you can tell us that percentage and what that would be in meters squared, that would be helpful. Thank you.
If we increase it to 5%, it'll be about 4.16 meters squared.
Okay, thanks.
Sorry, through the chair, that was 4.16 meters square?
Correct.
Okay, thank you.
Okay, so that's an amendment to the amendment, which is good. Thank you. All right, maybe we'll take it into committee now and look for a decision. Okay, who wants to run with this one? Mr. Reed?
Yeah. I think this is okay. I mean, I think the applicant is showing goodwill. It's still a very small percentage of soft landscaping, but the fact that city staff is supportive of this application, I think, tells me that they think that this is part of the established pattern in the neighborhood. And the fact that it's improving the existing condition is a positive element for me. The actual building application, I think, is very sensitively done. I think it's masked to avoid any impact on the neighbors. I think that's very thoughtfully put together. So I'll move approval of the application as amended twice, subject to urban forestry condition 3 and subject to the planning conditions.
Thank you. Do we have a seconder? Ms. Crawford, thank you very kindly. Okay, all those in favor of the amended application? Wonderful. You have a unanimous approval, sir. Thank you. Okay, moving on to item number 13. Item number 13 is 5, I'm trying to figure out how to pronounce this. DYNEVOR? Hope that's close enough. DYNEVOR Road, and the purpose of the application to construct a new 2-story detached dwelling with a front covered porch with stairs, a rear basement walkout with terrace, and a rear ground floor deck with stairs. Committee had before the following communication: copy of plan of survey, site plan, floor plans and elevations, 6 photographs of trees in the subject property, a covering letter from the agent, an arborist report, presentation materials from the agent, and we also have staff report from urban forestry.
For you, Mr. Chair, we have the agent online and 1 registered speaker online in support.
In support, okay. Mallory Nevas, are you there?
Yes, I'm here, Chair.
Hi, good afternoon. I don't know if you've got somebody in support. I'm not sure if they need a presentation.
Yeah, I mean, at the council's advisement, I'm fine to not do a presentation if you don't have any questions, but I have one prepared just in case. We note that there are no conditions from Ravine staff, but I'm not entirely clear on whether or not we have any conditions from planning staff on the application.
As far as I can see, there aren't any conditions attached to this particular application.
Mm-hmm.
So ravine and natural features also no conditions. But let me see if my colleagues require a presentation or not. None. Seeing none. Any questions at all? None? Okay. I'm not sure if your person in support needs to speak, but let's ask. Do we know if the person needs to speak?
I believe the person who's registered to speak on behalf and support is actually the owner. So I'm the owner's agent, and the owner's online as well to answer any questions in case the committee had any.
Okay, so this is Richard Dowson, I take it.
Yes, that's correct.
And does he need to speak or at all or not?
Only if there were any questions directed at me that Mallory may need assistance with. Otherwise, I have no comment to provide.
Thank you, Mr. Dawson. I take it you don't need a presentation at all. Thank you so much. Okay, we'll take it into committee then. Okay, who wants to run with this one? Mr. Ghosh, thank you.
It seems pretty straightforward. It's an odd lot, and I think that's really what has sort of precipitated the need for these variances. I know there was opposition on record, but I don't actually see any adverse impact of approving these variances, and therefore, in my view, they're minor, meet the 4 tests. So I would move to approve it.
Thank you very much, Mr. Ghosh. Do we have a seconder? Ms. Crawford, thank you very much. All those in favor? Thank you very much. You have your approval. Thank you. Okay, moving on to item number 14. All right, item number 14 is 17 Bernard Avenue. The purpose of the application is to alter the existing rear one-story detached ancillary building, a one-car garage, by constructing a one-story addition in front of the existing garage. This altered ancillary building will contain 2 tandem parking spaces. The committee had before it the following communication: copy of plan of survey, site plan, floor plans, and elevations, revised site plan, floor plans, and elevations, 6 photographs of the subject property, email correspondence between the agent and Heritage Planning, email correspondence from the agent, arborist report, correspondence from the agent, and we also have staff report from Urban Forestry.
Through you, Mr. Chair, we have the agent here in person and no registered speakers.
Good afternoon, Mr. McCormack. Name and address, please, for the record.
Good afternoon. It's Christopher McCormack at 22 McKee Street.
Thank you. We have before us 3 variances. There's nobody in opposition. But let me see if my colleagues require presentation or have questions for you. None, seeing none. None. Mr. McKay, you okay? Yep. Okay. Doesn't look like we need any presentation. So we'll take it into committee and look for a decision. Thank you.
Thank you.
Okay. Mr. Reid, sure thing.
Thanks, Chair. I think this is a reasonable application. I note that the soft landscaping, while it is deficient, has improved significantly. And the garage addition is just going upon what was a paved area to begin with. So I don't see a kind of additional negative impact of that. And there has been some improved landscaping suggested in the rear. So I think it's, even though the rear yard soft landscaping is low, it's a material improvement, and the negative impacts of the other variances, I think, are really minor. So I'm happy to move approval of this application subject to Urban Forestry 2.
Thank you, Mr. Reid. Do we have a seconder?
I would second that.
Ms. McKay, thank you. Okay, we have a motion on the floor. All those in favor? You?
No, I'm opposed.
Sorry, you're opposed?
Yep.
Okay, sorry. So we have a big one. If I could just go back, Mr. McKay, did you second? You
Yeah, yes, I did.
seconded. All those in favor? 304. Okay, sorry, Ms. Crawford, I couldn't see your left hand.
Sorry.
Thank you. Okay. And all those opposed? 1. Thank you. You have an approval, sir. Thank you.
I just think the soft landscaping is light, and there's no way to really improve it with the application as is. So that's my rationale.
Sorry, and through the chair, was that with the urban forestry condition?
If Urban Forestry 2.
Yeah.
Thank you. Okay. Moving on to item number 15. Item number 15 is 80 SCOLLARD Street. Purpose of the application is to permit a massage therapy use on a portion of the ground floor area of the 3-story mixed-use building. The existing recreation use, Pilates studio occupying the basement floor, office units occupying the remaining portion of the ground floor and the entire second floor, and 1 residential dwelling unit occupying the entire 3rd floor will be maintained and unaltered. Committee had before it the following communication: copy of plan of survey, site plan, floor plans, elevations, covering letter from the agent. We have email correspondence from Heritage Planning. We also have correspondence in support from 106 Cumberland Street, and we also have correspondence in opposition from 101 Scollard Street.
Through you, Mr. Chair, we have the agent here in person and no registered speakers.
Thank you. Good afternoon. Mr. Milton, name and address, please.
Good afternoon. Peter Milchin, 192 Lakeshore Road West, Mississauga. This is a very straightforward application. I don't really have much to say unless you have questions. I want to point out that you did receive a complaint or objection from a resident at 101 Scollard Street on April 22nd. The concerns raised in that are really addressed in the letter from Ms. Kang, who would be the tenant here, and that letter was submitted March 26th, so well in advance. Ms. Kang is a registered massage therapist. She practiced at Cumberland Street for several years. She is a member in good standing of her professional organization, and there are no physical alterations to the building. I think it's a very minor request and will have no impact on the community or any neighbors.
Thank you, Ms. Milton. Yeah, I did note the letter of concern or opposition and the nature of the opposition, and the applicant's response, I think, was very appropriate. So that kind of settled that for me. Let me see if my colleagues require a presentation from you or not, or they may have questions for you. Mr. McKay, any questions at all?
No, no comment, no questions. There's a wide variety of uses that are allowed. Thank you.
Thank you very much. Thank you, Mr. Milton. I think we'll just take it into committee now and look for a discussion and decision. Ms. Crawford, go ahead.
I would move for approval of the application. It's a registered massage therapist who's going in at Scollard in the Yorkville neighborhood, and the opposition does not really apply. Well, the concerns of the person who opposed have been met because it is a licensed, accredited massage therapist. So I would move for approval.
Thank you. Do I have a second? Mr. Reid, thank you very much. All those in favor? Mr. Milton, you have a unanimous approval.
Thank you very much.
Oh. Moving on to item number 16 is 8 Earl Haig Avenue. Purpose of the application is to alter the existing 2-story semi-detached dwelling by constructing a new rear 1-story ground floor addition with a porch and stairs. The existing rear ground floor addition, rear ground floor deck, and rear rooftop deck will be demolished. Committee had before it the following communication: copy of plan of survey, site plan, floor plans, elevations, 2 photographs of the subject property, and there we have 2 form letters in support signed by owners and occupants of 6 and 10 Earl Haig Avenue.
Through you, Mr. Chair, we have the agent online and no registered speakers.
Thank you. Mr. Davis, are you there?
Yes, I am.
Hi, good afternoon. We don't have any anybody in opposition, so I don't believe we need a presentation from that perspective. We have basically one variance that is being requested an FSI change. Let me just see if my colleagues have any questions for you or require a presentation at all. Seeing none, we'll take it into committee and look for a decision for you. Thank you.
Thank you.
All right, who wants to run that? Mr. Ghosh, thank you.
This is an FSI variance only to do a very small rear port addition. So I would move to approve it.
Thank you very much. So we have a second, Mr. Reid. Thank you. Oops. All those in favor? Thank you. You have your approval, Mr. Davis. Unanimous. Thank you. And moving on to item number 17. Item number 17 is 112 Rose Park Drive, and the purpose of the application is to construct a new rear two-story detached ancillary building containing one garden suite with basement, a side west cantilevered second story, and a side north one-car carport structure. Also to reconstruct the side west driveway and demolish the existing carport within city's right-of-way abutting Mount Pleasant Road. There will be a total of 2 residential dwelling units on this lot, 1 unit occupying the main dwelling and 1 unit occupying the ancillary building. The committee had before it the following communication. Copy of plan of survey, site plan, floor plans, elevations, 3 photographs of trees on the subject property, a covering letter from the agent, email correspondence between the agent and supervisor transportation review. We also have correspondence in support from 103 Rose Park Drive. We have opposition correspondence from 142 Rose Park Drive and 150 Rose Park Drive.
Through you, Mr. Chair, we have the agent online and no registered speakers.
Thank you. Good afternoon.
Good afternoon, Mr. Chair. My name is Enzo. Oh, sorry about that.
I interrupted you. Please go ahead. Name and address, please.
It's Enzo Lacasano from Arch CWG, located in Toronto at 1245 Caledonia Road.
Thank you so very much. We do have folks, I don't know if we have anybody speaking to this one at all. None. So we don't have anybody in opposition that will be speaking at all. So we don't need a presentation from that perspective.
Okay.
But let me just ask my colleagues if they'd either like a presentation or may have questions for you. Mr. Reid has a question for you.
Thanks, Chair. Hi, I'm just noting in your letter, you've referenced the removal of the carport that's in the right-of-way.
Right.
And the landscaping of the paved part of that. Are you okay if we were to approve this to include that as a condition of approval?
Oh, absolutely, because this was working with, actually, if staff brings up the photo, it'll put a self-explanatory.
Yeah.
Yeah.
Yeah, I saw the photo and where it is and the paving underneath. And I just want to, I think it's an important part of the application to have that
Absolutely.
removed. Okay, thanks a lot.
Because transportation, we agreed that we would reinstate the boulevard and provide the landscaping that was there, or I guess originally way back.
Way back, yeah. Okay, thanks.
Yeah.
Wonderful, thank you. All right, any other questions? None? All righty. Who would like to run with this one? Mr. Reid, thank you.
Thanks, Chair. I think this is a well-designed new building on this lot. The garden suite makes sense, and I think the way that they've incorporated the parking into it lessens impact on both the main house and on the neighbors to the rear. And I'm glad that the illegally constructed carport and pavement will be removed. So I'll move approval of the application, but with the condition, just capturing the language that's in the applicant's letter, that the carport will be removed and the area underneath it will be restored to soft landscaping in the boulevard.
Thank you very much. We have a seconder. Ms. Crawford, thank you very much. Okay, Okay, all those in favor? Thank you. We have a unanimous approval for this application. Thank you. All right. Move on to the last item for this.
Sorry, I just want to clarify one thing. I said that that was constructed illegally. I don't know if that's true. So I'll just say that for non-prejudice, just the parking structure to be removed.
Thank you. Duly noted. Okay. We move on to item number 18, which is 27 Conway Avenue. Purpose of the application to construct a new one-story ancillary building to contain one garden suite in the rear yard. There will be a total of 4 residential dwelling units in this lot, 3 units occupying the main dwelling and 1 unit occupying the ancillary building. The committee had before the following communication: copy of plan of survey, site plan, floor plans, and elevations, foundation plan, 7 photographs of the subject property, decision number affecting the subject property, presentation materials from the agent, staff report from urban forestry, and correspondence in opposition from 29 Conway Avenue.
Through you, Mr. Chair, we have the agent online and no registered speakers.
Thank you very much. Good afternoon, Mr. Benkowski. Are you there?
I'm here, Mr. Chair. How are you?
Very well, thank you. I hope you're well too.
We'll see how this goes.
Thank you. Do we have somebody in opposition or?
Through you, Mr. Chair, there's no registered speakers.
No registered speakers. Perfect. Thank you. We don't need a presentation from that regard, but let me just see if my colleagues have any need for a presentation or would like to ask some questions. Any question? Mr. Reid has a question for you, Mr. Benkowski.
Thanks, Chair. The neighbor did raise an important point, I think, in terms of the sufficiency of the emergency access to the rear. Can you comment on that?
Through you, Mr. Chair, yes, Mr. Reid. So there's a couple of things that are taking place here, and I'm gonna leave the variances alone unless you want me to speak to them.
No, that's fine.
Yeah. So there is in my support material, I have put in there is a shared right of way between the 2 properties. I can tell you that the city at this time, I've actually just found out this morning, is reviewing if these right-of-ways for secondary suites and garden suites can be used by the adjacent neighbors. So what I would say is, at this time, I'm not 100% sure if that right-of-way can be used, but keeping that in mind, through you, Mr. Chair, Mr. Reid, if the neighbor were to not provide that limiting distance agreement, this would not matter and they would not be able to construct a garden suite. Now, what I would say to that is, at any time, this property could change hands and an individual could agree to that limiting distance agreement. This neighbor might change their mind, I'm not sure. But I can tell you at this time, I know the city is reviewing it for secondary suites if they can be used. And by that, I mean the portion for the access from that right of way.
Right. Okay. So you're doing this more as like a preemptive, future-looking approval.
Through you, Mr. Chair, correct, Mr. Reid. If it had to become that, then yes.
Okay. Thanks.
Thank you very much. Mr. Ghosh, any questions? Any thoughts?
No. So that the neighbor in opposition isn't here, nor their agent.
Okay. I don't have anybody in not present.
Yep.
Hasn't requested.
I don't have questions. I have thoughts on the letter from the lawyer, but I don't have questions.
Yeah.
So I'll save them for committee.
All right. Thank you. Mr. McKay, any questions from your end?
No, none, Chair. Thank you.
Thank you kindly. Okay, so we'll move on. Thank you, Mr. Benkowski, for that. We'll take it into committee and look for a decision.
Thank you, sir.
All righty. Who wants to?
Yeah. So I noticed this letter as well, and I was kind of hoping the lawyer would be here so I could ask them some pointed questions, because I think it's my view is it's not legally correct. I mean, why would you need a limiting distance agreement which would be to say, oh, we won't put a fence up, which would make the access less than the amount required by the fire. But why would you need that agreement if you legally are barred from putting up that fence because there's an easement on the survey? This letter reads to me as though this lawyer didn't read the survey that had a right-of-way that says right-of-way right through there. And then are the neighbors saying that if the firefighters are coming in to access the backyard to save someone's life, they're going to go out there and block them? It just, given that a fence legally can't be built there, and we're talking about fire egress, I just don't see how it's an issue. I mean, maybe I misunderstand how the building code will interpret the however many meters are required, but I just don't see it in this situation. So I just saw it as a neighbor who isn't happy with the proposal as a whole, using a lawyer to try to find a technicality, but that technicality doesn't actually apply in this situation.
And would this be something that would be highlighted when a building permit is being sought?
Through the chair, yes, I was just going to say, and this would be reviewed at building permit regardless. So what you have before you is the minor variances in which to make your decision. And then at the building permit stage, the building department would deal with any such matters if that were the case.
Oh, thank you. That clarifies it a lot. Thank you. Okay, so we'll take it into committee and look for a decision.
Sure. The rest of the variances are all quite small, very small lot area variance. The others are having to do with the setbacks, but are small deviations, setbacks, eaves. Anyway, they all are pretty small. So it seems like a garden suite that is on the whole reasonable for the site. And given my opinion that the objection doesn't really have merit and in any event deals with an issue that's not before us, I would move to approve it.
Thank you.
Urban forestry, I think.
Oh, yes, thank you. Thank you, Gary. Subject to urban forestry 3.
Do we have a seconder, Mr. McKay? Thank you.
Yes, I'll second that. Thank you.
Okay, all those in favor? Mr. Benkowski, you have an approval, unanimous. Thank you. Okay, and that's the end of this morning's session.
Yes, through you, Mr. Chair, we will break for lunch and we will resume at 2:13 p.m. for the commencement of the afternoon session. 2:13 p.m. Thank you. Everyone shut off your cameras and mute your microphones. Staff, please mute the room. Thank you.